Let's continue.
Thank you, Chair. Chair, during the lunch adjournment, I drew the attention of Mr. Burger to two versions of the procurement policy of Denel. Mr. Burger, do you have available there the first bundle, bundle 1?
I do have, Chair.
I referred you first to page 735.
I've got it, Chair.
And that's the company policy on procurement of the effective date. You'll see on page 735, the 25th of August 2008. And the other one that I drew your attention to is at page, in the same bundle, page 827.
I've got it, Chair.
That seems to be the next version of the supply chain management policy that that was effective from 19th of November 2014.
That's correct, Chair.
Now, as I understand it, the second policy coming into effect only in November 2014 did not apply to the procurement of the platform hulls that took place earlier in 2014. Is that correct?
That's correct, Chair.
So if we go back to page 735, it seems to me that there is nothing specific as to whether it should be a public tender, an open tender advertised in the media for anybody and everybody to tender.
1 second, Mr. Kennedy, I haven't got yet where you are.
Page 735, bundle
Is it
1.
in another bundle, not the one that has
I'm
got...
sorry, Chair, I indicated it's bundle 1.
Yeah,
Perhaps your registrar doesn't have it. Looks like he's still trying to find it. I beg your pardon, Chair, I didn't
No,
notice
that's
it.
fine.
So, Mr. Berger, are we agreed that the policy at page 735 is the one that applied at the time?
That is correct, Chair.
That's at the time of the platform hull contract. And it appears to us that there was nothing specific to say whether you had to go out on a publicly advertised tender, an open tender, or whether 3 quotes in an RFQ process was required.
That is correct, Chair.
Right. Now, you made an important point.
Are you able to tell me which particular clause or clauses appear to be the relevant ones?
With respect, there doesn't appear to be anything that deals with...
Or is there nothing that talks about how tenders are supposed to be handled?
No, not in this...
Not on this one.
No. In the later version there is, but that wasn't applicable at the time.
Oh, okay.
Now, Mr. Berger, you made an important point earlier that, of course, you can't say whether this particular policy or any of the policies of Denel necessarily, as you put it, complied with the Constitution. And presumably also you mean with the PFMA and the Treasury regulations. That's right.
That is right, Chair.
That's not your area of expertise. You have areas of expertise elsewhere. And presumably you would rely on your colleagues at Denel to ensure your supply chain management colleagues and your finance colleagues, etc., to deal with that.
If I may add, Chair, we also had our own legal department, and these were collective decisions.
So these were?
Collective decisions.
Right.
Well, you see, my expectation is that people who occupy positions within the public service, SOEs, government departments, from a certain level of seniority, they would at least have an idea of what kind of legislation or regulations apply to their business or to what they have to do. They might not be experts or specialists, but they would have some idea, and they would know who to consult if they were not sure or if they wanted to know what the position is. That is, to consult somebody, some people like those who are in the supply chain management department in the organization, or the legal department in the organization, or even outside lawyers, where it's deemed necessary. Now, I would have expected that somebody occupying the position of CEO in DLS, such as yourself, would have an idea that, well, PFMA or maybe even Treasury instructions, this is what it says, but whether it, how and when it applies in certain situations, you might need advice from the experts or specialists. But I would expect that you would have an idea. Is that an unfair expectation?
Chair, it's not an unfair expectation at all. I think you are right. The problem here, however, was that this was in a transition period. The National Treasury and its regulations changed, and we were running at 300 kilometers an hour, and in all honesty, that wasn't the focus of a person like me. But your point that a person working in a SOC should have a fair opinion, I've got no argument about that. I think it's a fair comment.
Yes, and I would think that by 2010, 2014, that would have been a period by which particularly people at certain senior positions in SOEs would know that there are always issues about compliance with PFMA and procurement policies and so on in regard to government departments and SOEs, so that they would be, I would think, much more careful to say, we don't want to do anything wrong. Therefore, if we are not sure, let's call in supply chain management people or legal department. Tell us, are we going the right direction? Are we not going to be in breach of anything? That would be also another expectation I would have. What would you say about that part of the expectation?
Chair, I repeat, your comments are valid, but we were running not a department, we're running a business.
Yes.
And in all honesty, the fires.
The focus
The focus was on different areas. The fire to deliver, to get the order, to keep the client satisfied, and so on.
Yes.
Those were the issues that kept me awake at night.
Yes.
It was not procurement policies.
Yes.
And I understand.
Yes.
It's wrong. I understand that, but that was not my focus.
Okay, all right. Thank you, Mr. Kennedy. Switch on your mic, Mr. Kennedy.
I'm sorry, Chair. I understand your concern that things were having to move fast, and one of your objectives from a business point of view to develop the business of Denel and advance the interests of its shareholder was to achieve business opportunities, not lose them, and not get bogged down. But would you accept that it still had to be done lawfully?
I do,
Yes.
Chair, I do.
Now, so if I may, I'd like to move away from the issue as to whether it was appropriate for you to go out for more than just the 3 bids that were invited. You indicated that you feel, with the benefit of hindsight and having heard the other witnesses, that it was inappropriate for you to have conducted negotiations with VR Laser after it submitted its price to negotiate a reduction in the price. Is that correct?
I accept that under the rules it was incorrect.
Yes. Now, have you heard the evidence and seen the documents that show that the when the RFQ process was followed and the quotations or the bids were received from the three entities, the two of particular relevance, being VR Laser and LMT, were very far apart. The cost of the items in question that LMT was bidding for would have involved approximately 150 million. Is that correct? Correct?
I cannot recall. I thought it was a little bit higher than 150, but I won't argue.
And the amount for VR Laser was approximately 260 million.
Correct, Chair.
Yes. And we'll look at in a moment at the memorandums that came from Ms. Malashlela's office. But what was then decided, as I understand it, by your management committee at divisional level, the DLS level, was that you should approach VR Laser to negotiate a reduction in price. Is that right?
Not exactly correct, Chair. What happened was, and I accept by saying this that we are going to get to the point why I was so adamant about VR Laser, but accepting that for a moment, I was approached by both Mr. Rian Tebes and Ms. Malashlela, and to say, and at that time, both of them supported VR Laser. They, however, said that the price is a real problem for the budget. My question was, did they win the competition fairly and squarely, regardless of the price? And they said yes. And I said, well, leave it to me. I'll see what I can do. So it was not an initiative that came from me. It was an initiative that said, this is the preferred supplier. The price is high. And what I then did is I did not get in my car and take people and drove there and go and sit down and negotiate. Originally, it was so unimportant that I didn't even really remember it. But hearing all the evidence, I recollect that I phoned VR Laser, and I can't remember my words, but I said something to the effect of, "You are obviously not serious about doing business with us. I mean, your price is ridiculous. Goodbye." That was the extent of my negotiation. So I was hoping, I must be honest with you, I was hoping that they'll see the light and do something proper and get. And what subsequently happened was they did solicit another proposal. Chair, at the time, I was convinced if I did not take the opportunity then, and if I waited until after the process was completed, and everybody that was involved said, no, it's okay, let's contract VR Laser, that they would have known about that long before it. It's just how the people talk too much. And I would have had no basis of negotiating a proper price. The price was unacceptable. So the policy, and I didn't know it then, because what I thought at the time was, because they were the number one supplier, I had the right, and I thought they were going to win, and I had the right, they were the recommended one, to negotiate with him. But I didn't negotiate, I just said, your price is ridiculous, and that formed a basis to negotiate later on. I had, as a matter of fact, it's not that I even argued with Ms. Malashela about not putting that, I supported it, that to not in the motivation put the reduced price in. But if we did not do that, Chair, there wouldn't have been an opportunity to reduce the price. Why would they, if they knew that they were going to get the work? So that was the reasoning, but I accept that policy states first award, then negotiate. I understand that.
So, would it be correct to say you accept that you may have or you did do something that was not appropriate, but you believe that ultimately you were doing it for the good of the now?
We saved millions because of that single phone call, Chair. So I truly believe that. I still believe that if I didn't do that, the price would have been much more. So I honestly believed it was for the best of the now.
Well, of course, the whole framework, if one uses the procurement processes, they are meant to ultimately achieve what is in the interests of the company, working within the framework and not outside. And not outside. You accept that?
I understood, understood, Chair.
Yes.
I'm not arguing.
And that there is a reason for, so to speak, banning any outside role other than within the framework. In other words, the framework, the company expects is that all of the role players will work within the framework and not outside. And it would discourage anybody from going outside. To say, whatever your suspicions or whatever, work within the framework, because those who have put the framework together believe that that's the best way of handling these matters. You would accept that?
I'll accept that, Chair. But I want to add that when we had that discussion, and I said, let me do something about this, I'll try outside the procurement policy. Nobody said, oi, you cannot do this. This is a problem.
Yes.
Everybody around that table wanted to see the price reduced. But your point is taken, Chair.
Yes.
100%,
Yes.
no argument.
Yes. Mr. Kennedy?
Thank you, Chair. I want to go back to a point that the learned Chair raised with you earlier, and that is what is expected of a CEO such as yourself at DLS. Let's just accept for a moment that your colleagues also wanted VR laser. And let's accept for a moment that nobody raised any objection to your going to negotiate. And let's accept for a moment that you were simply genuinely wanting to benefit Denel by getting a reduction in price. Surely, as part of your functions and responsibilities and duties as CEO, was not simply to get the best price for Denel, but also to comply with the rules, the law and the rules internally within Denel as to how prices would be achieved. And they were to be achieved in terms of prescribed procedure. Now, whether you liked the rules or not, you were bound by those procedures, not so.
Chair, I've already conceded to this point, yes.
Yes, yes. It just seems to me, Mr. Burger, that it may have been irresponsible of you not to go ahead and negotiate with him, when in fact the rules didn't permit it, as you now acknowledge. Why didn't you take the trouble to find out the rules beforehand? Or ask people who might have had a bit more expertise, for example, Ms. Malashlela or Mr. Mlambo at head office level?
I repeat, Ms. Malashela was in that meeting. When I made that phone call, I did not believe that I was transgressing at the time. Right. I can now see I did, but at the time,
Yeah.
Chair, yes, I've conceded to that point. I should have taken the trouble.
Yes, yes.
Now, one of the problems was that you had a limited budget for these items. Not
Correct,
so.
Chair.
Can you recall what that budget was?
I cannot recall exactly. It wasn't around R1 million per hull.
million rand per hull, and there were about 200 of them. So it was about 200 million. In fact, that is roughly the figure as we've seen in earlier evidence. Now, wasn't there also another issue that you had to consider? And that is in terms of the delegation of authority. You only had authority up to a certain point, not so?
Correct,
At
Chair.
divisional level. You may have wanted a lot more because of the decentralization advantages that you have argued for earlier before the chair. But you had to live with the fact that the delegation of authority then limited your authority, not so?
Correct, Chair, but I did not have a problem with the delegations at that point. I wasn't complaining about the delegations.
Okay, just hear me out if you would. Now, as it happens, the limit of authority in relation to a contract of this sort of order, in fact, there was a difference between contracts under 200 million and contracts of or above 200 million. And in the case of contracts above 200 million, you would have required the full board of Denel head office to approve this, not so?
Correct, Chair.
Anything above a certain limit but below 200 million would be subject to approval by the CEO, the group CEO.
Correct, Chair.
Was the negotiation to bring down the price, did that have anything to do with any attempt to try and avoid having to put the matter before the whole board? Perhaps in the interest of being quick so you didn't have to wait for the next board or whatever.
Chair, I want to reject that notion totally. That was not even remotely in our minds at the time.
Were you even aware of the 200 million limit?
I'm probably at the time, Chair.
Do you accept now that, at least with the benefit of hindsight, that if you are going to follow some sort of competitive process, as you did here to a limited extent by inviting 3 bids, and whether that was enough or whether you wanted a full tender, we've already dealt with. I'm not going to go back on that. But do you now accept, with the benefit of hindsight, that if a process is in fact competitive, such as a 3-entity bidder process, where you go out with a request for quotes from 3 bidders, do you accept that you have to be fair as between all 3 bidders?
Absolutely, Chair.
Yes. Now, what happened here was that you or your staff went out with an RFQ, presumably not you. You didn't issue it yourself, is that right?
Correct, Chair.
But you were aware of the process, not so, that it went out on an RFQ to 3 bidders.
I was aware, Chair.
And each of them submitted bids.
I was aware of it, Chair.
And you're aware that it was about 160 million for LMT, a little bit less, in fact, and around 260 million from VR Laser.
Correct, Chair.
We've already dealt with that. Now, was it not, do you accept now the wisdom and the need to, if you're going to allow any party to revise its price, if you're allowed to do that at all, you can't select one party to have that opportunity where the others are not selected. Not so.
Chair, the reasoning at the time was, in our minds, they fairly won the competition at their original price. That, and for that reason alone, did I have the guts or the inclination to contact them. If they didn't win, and if they were second in the scale, there would have been no way that I would have phoned just them to try and get them at number 1. And that was the reason why I did not even argue. As a matter of fact, I supported the fact that we cannot use those improved prices as part of the evaluation. I was under, my thinking at the time was, there was a recommendation, there was a multidisciplinary team that was part of that recommendation. They came up to an answer, they came to me, and I was fairly certain that that recommendation would be approved by Denel. And I took that opportunity to say, can't we squeeze them for a better price?
My question, I'm sorry, have you finished?
I think I've finished.
My question is, and we will come back to the justification for going to VR Laser to get a price. And I understand your point that you were aiming to get a better price so that Denel would end up paying less, and you would then achieve the objective of getting an acceptable product at an acceptable price. But at the moment, I'm dealing with something different. And that is this. There's a competition on the go in this RFQ process, not so?
Correct, Chair.
Yes. And Denel has to undertake the decision at the end of that competition process by comparing the three quotes, not so?
Correct, Chair.
Yes. Now, you did in fact allow VR Laser to change its price. And it went down from about 260 million to 195 million, correct?
Correct, Chair.
And that was achieved, you say, just through a phone call.
Correct, Chair.
Well, either you have the most remarkable ability to be persuasive in a phone call, or the other possibility is that VR Laser had just put in their 260 odd million tender recklessly and very casually because they thought this is going to be easy. Let's make fat profits out of Denel. Which one is it? Or is there a third that I've missed?
I'll be speculating on their behalf if I would give an opinion. But what I think happened was that there was a first round in 2012, I think it was. And in that first round, it was fairly clear that VR Laser was the most competitive one.
The most competitive in what sense?
In terms of price.
In terms of price?
Price, yes. And I think they were probably a little bit resting on their laurels in terms of price. I think they thought, we've got this in the bag, I think.
Mr. Berger, I'm not trying to be difficult or to catch you out. I'm just trying to understand your evidence. I understand that there was an earlier process in which they were asked to give some sort of indicative prices, but that didn't lead to an actual award. Is that what you say?
No, it didn't. No,
it didn't lead to that. And you say you think that they knew that they were probably going to get it, and you think they then exploited that by pushing up the price. How would they have thought that they were probably going to get an award of a contract that only took place 2 years later? And where would they have got that information from?
I don't know, Chair. I don't know. And I say again, I'm speculating. I don't know how that happened. I know I gave a very angry call to VR Laser. Yes, I think they had to sharpen their pencils.
Did you say lengthy call?
Angry call, Chair.
Oh, angry call.
Angry call.
Yeah.
So you were angry that they had abused their situation and come in with a rather cheeky high price?
I thought the price was too high, Chair.
Yes. Now, I just want to go back as to your speculation. Obviously, you're not stating this as a matter of fact, and I appreciate that.
I don't.
You don't have facts to back this up. But you see, I think, but do you appreciate that when Denel is an entity that was in some financial difficulty that required bailouts from government to get it out of its financial difficulties, where you're dealing with vast amounts of public money, and where there may have been, even on your own admission, some breaches of the law, of procurement policies which are legally binding, and where, as it happens later, it turns out that that the supplier in question actually has controversial links. Do you accept that it is appropriate for the public and for this commission to be entitled to look into how it comes about that a supplier gets business?
No argument, Chair.
Right. So when we look at this, it's important to understand whether this was a genuinely fair and legal and honest competitive process, not one in which there may have been funny business. Now, I'm not saying that there was funny business here. It's for the chairperson to decide at a later stage whether there was and to what extent. But the chair is entitled to look into whether there's a proper justification for business decisions. Now, there is a controversy that is raging in the media and in public debate and so forth as to whether VR Laser was getting this and a number of other lucrative contracts that we'll deal with in a moment, at least the DLS contract you know about, and the DVS contract that you weren't directly involved in. There's concern as to, well, how was this justified? Now, if there's a proper justification, then one may be satisfied that, as you've suggested earlier, the Gupta link, the state capture allegations, that actually had nothing to do with it. As you've said, this was a genuine bona fide lawful up to a point transaction. And if it was unlawful, that was bona fide, it was an oversight, it wasn't intended to favor anybody. You understand what the parameters of this and the objective is. Now, it just seems to me, and in fact some of the other witnesses such as Mr. Mlambo have commented on this, it just seems to me as an outsider, although Mr. Mlambo was an insider with expertise in supply chain management in the Denel context, he expressed real concern as to whether, in fact, this was a genuine transaction at all. And one of the points that he raised in his evidence before the learned chair was, can one take seriously a supplier that comes in with 260 odd million as its initial price, and then after a negotiation process happily brings it down, or maybe feels that it should do, but it ultimately voluntarily brings its price down to 195 million. Now you tell us that took a brief conversation, admittedly one in which you expressed a tone of anger. But it just seems to me that when you're talking about such a massive difference in price, something looks wrong. Something smells a bit fishy. Do you understand the problem?
Chair, if you look at the first iteration of prices, the LMT price was double the one they quoted. So we were used to a little bit of fluctuations in the price. That is so. It was a substantial saving, and I was very happy. I think the supplier were pushing the envelope. I think so. I think that 260 was not warranted. The issue here for me is what did we use to evaluate them? And in my mind, that was post the evaluation. They did come out number one, and therefore I had to do something to get the price down. But Chair, that is what happened, and the intention was to help Denel. Otherwise, why would I want to get the price down? What other reason can there be to get the price down?
Well, that's the problem, if I may interrupt, and I apologize for doing so. I don't mean to be rude. Isn't that the problem? The public and the commission need really to know whether this was a genuine reduction in price. Not only your own bona fides, but whether VR Laser were acting bona fide, and whether your colleagues in Denel were. So even if one accepts that you were in good faith and simply acting in the interest of Denel to try and bring down the price, do you not agree that this is a disturbing feature of those events, that VR Laser came in with what you've said is an unacceptably high price? And then magically, just from a short, albeit angry conversation, you managed to cause them to bring down their price massively.
Chair, I was under the impression that they after my discussion with them, that they were not going to get the business. And I think they wanted to make
That
sure
they were not?
that they were not going to get the business.
Oh, yeah.
And that is why, the reason why I thought they came down substantially.
Yes. Now you've mentioned that they were clearly so suited, and they'd been evaluated on the basis that they were better than LMT. But are you aware
Correct, Chair.
are you aware that the scoring that was done, not by you, but an evaluation team that was appointed in terms of the Denel policy, the evaluation team assessed the technical side, the triple BEE side, and the price. And LMT came within a whisker in terms of scoring, of the scoring given by the evaluation team to VR Laser. It was less than 1%. It was about 0.6% difference in the
0.7%.
scoring.
I'm aware of it, Chair.
Yes. And one of the main reasons why LMT did so well in relation to that issue was because their price was so much better. Correct?
Correct, Chair.
Yes. Now, why
Well-
didn't you then... Sorry, Chair.
Yeah, okay, continue.
Why didn't you then not take this approach? If you were looking at this with your colleagues, and a decision has to be made as to who, as the party to whom the tender should be awarded, doesn't this sound a logical approach? We have two tenderers that have an absolutely marginal difference, less than 1%, a negligible difference, I'm suggesting to you. But what is hugely significant is that if we go LMT rather than VR Laser, we're going to save about 100 million rand. Now, does that make sense to you? That could have been an approach you could have adopted, not so?
If we used the original price, we contracted VR Laser at the original price, there would have been. But the dilemma was, there was not 100 million. I was not prepared to pay 260 million rand.
Correct.
Because there wasn't
Indeed.
100 million rand lying available to do certain things with.
You had a budget, and you had to work within that budget.
Correct.
260 million would have brought them way out of the budget.
Correct.
Right. But there was another reason why you weren't prepared to accept the 260 million. And that is, even if you had the kitty of money, even if you had the budget of maybe 500 million, you wouldn't have done it because you thought it was an exorbitant price. Not so.
Correct, Chair.
And one of the reasons that it seemed to you to be exorbitant, and I think everybody would agree with you, is that it's 100 million more than one of their competitors, LMT.
Correct. Chair.
Correct.
Sorry, Chair. There's two reasons. We had a fairly good idea how much it should cost, because we had our tariffs, we had process times, we had material costs. So we knew what is a fair price and not a fair price.
Right. So you knew it wasn't in the 260 million ballpark. A fair price would have been more like 160 million
200
as a ballpark to 200.
I thought 200 was a...
You thought 200.
I thought 200.
But isn't the whole point of a competitive procurement process that whatever you may think, well, 200 would be a fair price. If you can get it for 150 million, that would be good news. You shouldn't say, well, let's pay 200 while we're at it, not so?
Absolutely not, Chair. If we could get it for 150 million, I would take it with a smile.
But the point is, Mr. Burger, you could have got it for 150 million, approximately, because that's exactly what LMT was offering you. And that's my point.
Chair, at this point, can I please say why I was not supporting LMT?
Yes, I thought I'd asked you that question about 10 minutes ago, Mr.
LMT.
Burger.
Yes, but before
LMT,
you do
yeah.
that, I'm sorry, Mr. Kennedy. Before you do that, I want you to go back to Mr. Kennedy's question that you haven't answered. He asked you whether you accept that it would have been an approach open to you or to Denel to take, to say, and Mr. Kennedy, you must listen carefully, I don't want to misrepresent what you were saying, to say these two companies were so close to each other in terms of the score. If the price of the one is so way above the one for the other company, we should go with the one with the lower price. Now, I may have misrepresented what you are saying.
No, with respect, you're spot on, Chair.
Yes. So, do you accept that that was an approach you could have taken, or Denel could have taken with justification, but you may have preferred a different one? But it's an approach that could have been legitimate.
It's an approach that could have been legitimate. I think it would have been irresponsible. But it's a legitimate
Well, I don't know
approach.
if it would have been legitimate, if it would have been irresponsible.
My honest
Yes.
opinion at the time was it would not have been in the best interest of Denel.
Yeah.
And this is
And
why...
I guess that will come out when you say why you did not support LMT.
Correct.
Okay, deal with that then.
Correct,
Yes,
Chair.
if you can deal with
Okay,
exactly.
Chair, I'll try and make it quick. Firstly, I just want to get the reason for the LMT acquisition off the table. It'll take me 2 seconds. I was the biggest promoter of buying LMT. I was very concerned when LMT was in a financial crisis, and the reason for that was they were busy with development work. The designs were not fixed yet. The design would have hung in the air. Nobody would have been there to finish the landmine protection. And Chair, I want to place on record a couple of defamatory things were said about me yesterday by Dr. Stefanel, but be that as it may, he is. I always respected him for his engineering capability and his marketing capabilities. I really thought, and I still believe, he's one of the brightest engineers I've ever met. And that is what drew me to LMT. So we also, contrary to what was said earlier, what was then done was we gave LMT a order on risk. It was a risk order with a prepayment, with the objective to help them. It was transparent. It was discussed with the board. Everybody. So we first step was we made sure they didn't go under. So the second step was to exercise our option to acquire these LMT. The first and most important reason, and this is what people don't understand, was we did not acquire them for their production capability. As a matter of fact, the reason why they went bankrupt in the first place was because they went from a design house, a design capability, to a production capability. That's why they ran into trouble in the first place. So we were, as Denel, we were on a level 4 system supply level, which means we were supplying turrets to the client. They were buying a turret, and then they would buy a different vehicle, a different product, like the vehicle, the weapon platform, from another supplier. Then they would buy ammunition from another supplier, and then they would buy simulators from yet another supplier. And Armscore then had the accountability, responsibility to it's just 20 screws, and then the turret is on top of the vehicle, and you put the ammunition in the car, and then everything's fine. And then if as long as it works, it's fine. But if you miss a target, especially on a complex system where you fire moving to moving systems, if you miss, who's to blame? And what then happened was, and this is why Armscore went out on first they went out for a turret and vehicle And then they decided, no, we're going to go out on a level 5 product system, which is inclusive of all these things. So we knew that if we wanted to compete in that area, we needed to team up with somebody, and we teamed up with EADS. That didn't work, and we had to grow our own capability. So what a combat system consists of 3 technical areas. It's firepower, which sits in the gun and the turret. It's protection, and it's mobility. Those are the 3 technological areas you need to understand if you want to play in the area of a level 5. We thought Yates would bring that to us. It didn't work out. And at that time, I saw LMT with the design capability of vehicles, and especially the design capability to give protection. The flat bottom design technologies as an ideal area to strengthen Denel land systems. Not Denel land systems. On the contrary, I thought that what is lacking at LMT were, they didn't have proper process engineers, process design, their quality processes were lacking, the general management skills I thought was lacking, the financial management system was not, in my mind, proper. And I thought that is exactly what Denel land systems had. So if we could manage LMT as an extension of Denel land systems, then it would be the best of both worlds. And then, so the reason, the main drive for LMT was the strategic capability to ensure a proper level 5 system capability. I do concede, and I was the first to say, if we implement now all these things in LMT and strengthen their capabilities, then they can also be a supplier of fabricated stuff, they can be a supplier, they can even maybe build vehicles, whatever the case may be. I was really convinced of the fact that we can grow LMT into some supplier of substance, and I believe that with my whole heart. Why did LMT fail? Those processes were never implemented. In we started off like that. Stefan Nel was part of my executive team, my quality people, my process engineers and so on were in the facilities working there. I was at the board of LMT. I was working there. It was even announced publicly that they will be part of the Denel. And then they got a big contract from Saudi Arabia. And I was called into the office of the then group CEO, Mr. Sology, and he said, it's a conflict of interest for me to be so close to LMT. Henceforth, you should no longer be on the board. Your people should exit LMT, and you should contract LMT at an arm's length. And from that moment on, LMT was left to their own devices, and Denel managed through the board, or tried to manage through the board, LMT. So what happened then? I made a commitment, and I kept to my commitment by giving them orders. I gave them 7 substantial orders in those years leading up to 2014. The one was, and this is from, sorry, I just need to address because that's a point that was made, from a capacity, capability, and a financial perspective. So, from a capability perspective, I gave them orders. All of those orders had problems. I heard Dr. Nel say it was exaggerated, it didn't happen. Let me give you 2 examples, Chair.
Do you need to, Mr. Burger?
Yes, I think it's important, Chair.
Well,
I really,
please try and keep it brief,
I'll
because
try,
I'm
but
afraid we're going into all sorts of terrain that doesn't really seem to have direct relevance to the question that you're being asked to focus on.
I think it's got all the relevance.
All right,
Chair.
finish your points then, please,
Okay.
and then may I just develop my questioning with you, please.
Correct. Two projects I want to focus on. The first one was the ambulances. The ambulances went through a process where we went through various iterations. At the end of the day, I begged the client to accept them, even though they did not comply to specification. And I made a personal promise that I will ensure that if they ever give problems, he will be happy. The second thing that happened, 15 Caspers that were delivered to the United Nations started cracking. I didn't have a big problem with the fact that they cracked because people make mistakes. The problem was when I asked to rectify those Caspers, they came and they just welded plates over the cracks. And obviously it's armor steel. They cracked next to where they were welded. So what then happened was we were a single source, or preferred, sorry, not single source, a preferred supplier to the United Nations at that point. So what then happened is the United Nations threatened to blacklist us. Denel Land Systems brought 15 Caspers back, had them rebuilt, and sent 15 Caspers back to them. Now, my dilemma was not so much that there was a problem. My problem was that LMT never admitted to say, maybe there was a problem from my side, how can I fix this problem? Denel Land Systems, from a financial perspective, ended up paying to bring the vehicles here and send them back and rebuild them. It was just shy of 30 million rand tag that Denel Land Systems and Denel picked up. This is a safety critical item, Chair. A hull for a Casper is a simple thing. It's been built for the last 60 years. It's a simple thing. To compare that with the Hoefyster hull is like chalk and cheese. So that's the first point. The second point I want to make is they had a capacity problem. They just got the biggest order of their lives to Saudi Arabia. By the way, also for turrets, which they did not place on us. And I want to put on record.
Sorry, which they didn't?
Place on Denel Land Systems. We were the turret house in South Africa. They preferred not to buy the turrets from us. I went to Stefan Nel and said, please, this is irresponsible. Let me then just help you to do the design for the turrets. Then somebody else can make the money out of the production, but so that we ensure we've got a safety turret system there, which we then did. So with that as background, when somebody came to me and said, and that just happened. I mean, that was fresh in our minds to say, here is LMT. They've halved their price from their previous quote. I just knew that their previous mistakes were for my burden, financially and otherwise, and they halved their price. I said, I don't believe this. The cost of that thing is going to increase, and it's going to be for my burden.
So you didn't believe that the 160 million roughly was a genuine price?
Sorry,
is that what you're saying?
I'm saying that. I'm saying at the time, the people in Denel Land Systems were skeptical that they would be able to do that. And if they did it at that price, it would probably be at a loss, which again would have been for Denel's. So to come back, if we had to place money in LMT to bring them up to standard, as one of the suggestions, it is not as simple as that, Chair. Because we were only a 51% shareholder. So if we brought 50 million to the table, you have to dilute the other shareholders or do something. You can't just bring in money from nowhere. And to be honest, Chair, it's a long way. I've calmed down a lot since then. But if somebody asked me then, please give some more money to LMT so that they can be up to standard, I would have aggressively fought that notion. So that was the reason, Chair, which I said, I would rather somebody by the way, I wanted to say this as well. We had a scoring system, how we rate suppliers. And at the time, VR Laser was in the top sector of suppliers, And LMT was right at the bottom. It was
So, sorry, in terms of what?
in terms of customer satisfaction.
Sorry,
To
customer
satisfaction. So it is quality, it's on-time delivery, it is do you accept that you've made a mistake, are you going to fix your mistake, those sort of
And
things.
was that reflected in the criteria for the scoring of bids?
Not at all. It was not, but it was the engineers. I wasn't part of that. But
Yes, but sorry to interrupt, Mr. Berger, and you must please allow me to not to cross-examine you, to question you at appropriate stages,
100%.
rather than going on and on and on and giving us a long session, which makes it very difficult to unpack. The evaluation was done in terms of the criteria that were laid down in terms of the policy. not
Correct,
so.
Chair.
You thought that customer satisfaction was something that should have been in the criteria, but it wasn't. You couldn't reinvent the criteria. You were bound by them, whether you liked it or not, whether you think it was a good idea or not, whether the chair of this commission thinks it a good idea or not, is with respect irrelevant. That is
Agreed,
what
Chair.
was laid down.
Agreed, Chair.
So once again, rather like the decentralization type of argument, isn't this something you wished it had been a certain way, but it wasn't. And you've already conceded rightly that you were bound by the situation that you were facing.
Supported and agreed, Chair.
Yes.
But
Now-
sorry,
Sorry, yes.
the point being, those criteria were followed and VR Laser won the competition.
But by 0.6%.
True.
Are you
Well-
seriously suggesting that because they got a higher score, are you suggesting that you were bound to give them the contract because of that?
Yes, Chair.
Yes.
Yes, Chair. They won the competition.
So they won the competition.
They won the competition.
But in terms of procurement policies, you're not necessarily bound to award a contract to a particular supplier where it has a score better than its nearest rivals. There is a measure of discretion allowed, and particularly where it is 0.6%. So it can't be right that you were bound to give it because it scored the highest. You may have felt you were bound to give it because you thought only it could provide the best service. And in fact, many passages in your affidavit, I'm not going to take you to them, but many passages seem to suggest exactly that you, Mr. Berger, maybe for very good reason, thought that VR Laser were a wonderful supplier and that LMT was not a wonderful supplier. In fact, it had problems. But that therefore, come what may, VR Laser should get the contract. It wasn't because they scored 0.6% better. It's because you felt that they were way above LMT and that LMT, in fact, shouldn't really be considered at all. Not so.
Chair, I stated it in writing, in emails, that I was not prepared to support VR Laser if they did not win the criteria based on the original proposals made.
Yes, and
that is so.
well, we know that they had won, but they won by a marginal difference. We've been
Correct.
through all of that already.
Correct.
So
But-
can I just go back to your earlier evidence? Effectively, if I understand your evidence correctly, and if I've got the wrong understanding, please correct that for the benefit of the chair. You seem to be saying whatever difference in price there may have been between LMT and VR Laser, only VR Laser should have got that contract. Firstly, because you couldn't believe the price of 160 million of LMT. You thought that was it was just a bit of nonsense. It had reduced from their previous price dramatically, and you felt that was suspicious. VR
Correct,
Laser, you managed to get down their price, but you felt that was acceptable.
Correct.
That
Chair.
was a massive reduction on their part, but that you felt was all in order. And then on top of it, you felt LMT just couldn't do the job. Isn't that really what you're saying here?
Chair, at the time, the pain of paying 30 million, of looking a client in the face, was very fresh in my mind. That is true. Firstly. Secondly, I did not dispute the fact that LMT can do a lot of work. And it's difficult to answer these questions without elaborating, but like a gun barrel, which the Denel Lane Systems manufactures, after they've decided to outsource more or less everything, because it's a safety critical item, I thought the hull was a safety critical item. My problem was not so much that at all costs VR laser must get the work. That was not my argument. My argument was, this is a safety critical item. It is, we've just gone through holes that, for whatever reason, that cracked, and if we have something like that on Hoefyster, it'll be catastrophic.
So, Mr. Burger, are you saying this, and I go back to my last question, are you saying that you weren't impressed by LMT's price, partly because that they had dramatically reduced it, but secondly because you felt that they couldn't provide a sufficiently safe product? Is
Correct.
that what you're saying?
Correct, Chair. Under those circumstances.
Now, then I have a further difficulty. Why on earth does DLS go to the trouble of asking LMT to submit a price, a bid in the first place, if you know, so certain as you are now, that LMT isn't going to be able to supply a safe price? This was not an open tender where somebody sees in a Sunday Times or Citizen a newspaper advertisement, request for proposals from Denel. Not so. You didn't invite the market to submit tenders. And you might have got tenders if you'd done that from all sorts of people who didn't know a turret from a bar of soap. But here your company went out, it decided we're not going to go out on an open tender, we're going to go out as we normally do on an RFQ. And we're going to go out to people to submit bids in order, presumably, to get the best price. And who we're going to select? We're going to select VR Laser, LMT, and DRD, presumably because we think that they are people who can do it, and we want them to compete against each other to see who's going to be the best price. And so what happens? LMT tenders a price, VR Laser tenders a price, and lo and behold, it's 100 million difference. Now you seem to be saying, well, you can't accept the genuineness of their price, so it's not a true comparison between 150 million and 260 million. So it's not a true price. But most important, LMT couldn't be relied on to do the job. Why on earth go through the whole process of asking them all to submit quotes against each other? Why go through a process of having a committee that evaluates them and tests all sorts of things and works out a score and so forth, if Mr. Burger behind the scenes has already decided long ago, well, LMT shouldn't be considered? It just doesn't make sense to me.
Fair comment, Chair. I think it's a fair comment at that point. But please remember, the decision to go to those three suppliers was not my decision.
Right.
That was a decision taken before 2012. So by 2012, these problems, I was still sitting on the board of LMT. At that stage, I thought I was told to contract them at arm's length, but I thought they had a more than fair probability of getting the work. And we went out to 3 tenderers. These problems I'm talking about now wasn't on the table.
But they were on the table at the time that the evaluation committee did its scoring. And the evaluation committee had to score not only the price, where obviously LMT had a huge advantage,
Correct.
but also technical capability.
Correct.
Now, surely your colleagues who were involved in the technical evaluation for purposes of scoring could and should have taken into account exactly the problems that you're raising. And despite that, they say, well, we're giving them some points. They gave them less points than VR Laser, presumably because there had been problems.
Correct, Chair. Sorry, the first question was,
yes,
why did we even consider LMT at the time?
Yes.
So I'm just saying, this process started already in 2012.
Yes, you made that point.
And in 2014, It was basically a continuation of that process.
Indeed.
That is why they were scored. I'm venting my personal frustration at the time, but that I don't believe influenced the scoring system, because I was not interacting with the people doing the scoring for that. They made up their own minds. They evaluated and on that VR Laser won. So when they brought it to me, I wanted to make sure that they win, and if they won, I wanted I had all these things plus the capacity problem with Saudi Arabia at LMT. I just said it'll be irresponsible, and again, the Saudi Arabia wasn't successfully concluded for these very same reasons. Chair, I really think it would have been irresponsible. That was my point at the time. But having said all of that, and I want to make that point, I accepted and I put it in writing that it was not my decision. I said, it is Denel head office decision. I've given them my reasons. Please make your decision. But in the meantime, the technology transfer to be able to do welder training, that slot is passing us by. And I decided at Denel Land Systems cost to send both LMT and VR Laser personnel to Finland to get their training. So I was, it's not that I said I will not do that and I will walk away. I was prepared to implement the decision of Denel, but I was making a point, this is a safety critical item, it would have been irresponsible.
Well, I think you said, and maybe other witnesses also said, that the price, original price, that VR Laser had quoted.
Yes, Chair.
Was, I don't know whether they said out of budget or quite too high.
It was double the second price, Chair.
Yes. I got the impression, and you must tell me if it's a wrong impression, I got the impression that the way that price was high, there was no way Denel would approve that price as it was. Is my impression correct?
It's correct, Chair.
Now, the question that arises for me is, how do you take the decision that VR Laser is the entity that wins above another or the others, when realistically you know that you can't appoint them on the price they quoted as is? Because my thinking is that you should only say this is the bidder or the entity that wins if you can afford that price. But if you can't afford that price, you should not appoint that entity. You should, that entity should lose some points for that kind of price. And if that approach is correct, then LMT could easily have won if VR Laser lost some points because they were so close in terms of scoring. And therefore, when you make a call to VR Laser and get them to reduce the price, you are in a way depriving LMT of a chance to win. Because if their price is so high you can't afford it, they should not win. The next entity that should win is LMT. What do you say to that?
Hindsight is a wonderful thing, Chair. Maybe that could have been an argument. The way it worked was that we had a total budget for suppliers for the whole system. And there were big swings and roundabouts. In certain areas, because this wasn't something that was manufactured before, we didn't have a cost chain that was in time and accurate. So we had a budget and allocated amounts of money. And on top of that, we also had a risk provision because we knew that in some instances we will be wrong. So what we did was every supplier, every opportunity where we placed an order, we looked at what was the budgeted price and what was the amount left in our slush fund, in our risk provision. And it did happen that people were over the budget, but they did win the competition, and it was a good supply, and everybody agreed with that was the best decision, taking transformation, taking capability and price into account. The person that won, even though they're over budget, then we did place orders on them, taking account of what's the total budget of the system, can we afford it, and obviously as a businessman, I try to get the prices down as low as possible in all cases, and then also would send the people back and say go and renegotiate. But that was what you say, Chair, might have been an approach, could have been a good approach. I'm not arguing that, but it wasn't the approach. It wasn't the way we did it with nobody.
Of course, the question goes to the issue of fairness. That's where it goes to.
Correct.
To say LMT may be justified, may have been justified to say, because VR Laser quoted you a price that was too high, that was unacceptable to you, you shouldn't have asked them to reduce their price. You should have gone to the next competitor whose price you could afford, and that was me. Therefore, by getting them to reduce the way it was done, you deprived me of getting this job. You've deprived me of the opportunity to get this job. You understand?
I understand 100%,
yes.
Chair.
Okay. Mr. Kennedy?
Thank you, Chair. And that wasn't done.
No, that wasn't done. That was never done, and it wasn't the process that we followed.
Now, what was also not done was to go back to LMT and to say to them that you, Mr. Burger, and maybe some of the colleagues who agreed with you, were of the view that LMT should not be given this contract, even though their price was so low compared with VR Laser, because they couldn't be relied on, because of the United Nations Caspers, which were different, where there could have been an opportunity for LMT to have a debate with you. You heard, didn't you, Dr. Nell's evidence where he said, well, firstly, Caspers are different from this Badger type of vehicle. Secondly, we had a valid excuse which was verified by an independent outside agency that put in a report to say that we weren't to blame. It was steel that was corroded from a supplier that we couldn't be blamed for. Now, it may well be that ultimately you wouldn't be persuaded by that, but wouldn't it be appropriate to at least ask them, give them that opportunity before you effectively disqualified them? Isn't that actually the bottom line? In effect, you disqualified them when they put in a very seemingly attractive price of 150 million, well, we're not interested in that price. We're not impressed by that price because we don't think that you can't do it seriously. But you would have been able to hold them to that price if you'd awarded them the contract, not so.
Correct, Chair.
Yeah.
But again, the Casper incident showed that holding them to something eventually becomes Denel's problem in any case.
I understand that, Mr. Burger, that rationale. But before you come to that decision, isn't it appropriate to be fair? You see, the chairperson has reminded you a couple of times now that it's not just a question of what would have gotten you a good price from VR Laser and you were satisfied that VR Laser was an excellent supplier at the technical side, but also what is fair.
Correct, Chair.
Because fairness isn't just something that's a nice to do if you can concept. It's what the Constitution says. We lawyers know it's in section 217. Every state entity, such as Denel, shall have a procurement system for the procurement of goods and services that is lawful, fair, competitive, cost-effective, transparent, and equitable. Fairness comes into it not just in the express word of fair, but also equitable and so forth. Now, it just seems that you don't, or at least at that time, didn't seem to appreciate that.
Chair,
You appreciate it now.
I do, and absolutely no argument. In my mind, the fairness came in that we went through a process where we had a closing date, we used the information for the closing dates, and that is what we used to do the evaluation, and VR Laser won. So that was where the fairness came in. The question about...
Sorry, Mr. Burger. It's been put to you a couple of times, both by myself and the learned chair, that fairness doesn't depend on who gets 0.6% superiority in score. It's a little more complicated than that. And even if the score was to the advantage of VR Laser, as a matter of law and fairness, it is not automatically required of an entity to grant it come what may. It makes perfect rational sense for a state entity that says, well, I see my evaluation committee has come up with a total score that gives X a score that is 0.6% better than Y, but if it's going to cost me a half or a third less of the price from Y, I should rather go that way. It's perfectly lawful and fair.
I accept that.
You accept that?
I accept that.
Okay. All right. Now, may we move from this aspect of the deal, of the platform hulls contract, to another issue that has been raised in the evidence. You dealt in your early stage when I asked you to indicate which category the platform hulls contract fell into. Completely compliant or not compliant or don't know. You raised the two issues. The one is that you went out on RFQ for bids, 3 bids. We've dealt with that. We've now dealt with the negotiation with VR Laser to reduce their price. You've conceded, to your credit, that with the benefit of hindsight was not permissible in terms of the policy.
Correct, Chair.
But there's another aspect. In fact, there are quite a few aspects that one could deal with, but I'm going to focus on what seems to be the most relevant. And that is Mr. Mlambo's concern. And that is that he hadn't approved this, and his approval was required under the NEL policies. Now, Mr. Mlambo was initially consulted about this, not so?
Not that I'm aware of, Chair.
Okay. Can I ask you, I'm not sure which bundle you have now in front of you. It's bundle 1. It's the same one we looked at for the procurement policy earlier.
Sorry, Chair. Prior to me going to Denel, Dennis Mlambo was not consulted. I know from my perspective...
I'm sorry, just say that again.
Prior to me going to head office to say, we didn't take it to Mlambo for approval. But I know there was a lot of consultation within the executives in head office, and they did speak to him.
They did speak to him.
Yeah,
All right,
that much I know.
Let's look at some examples of that in bundle 1.
Oh, I'm sorry, let's clear that. Are you saying they did speak to him, or are you saying they might have spoken to him?
No, I know they did.
That they did speak to him?
They did speak to him,
Okay,
yes.
all right.
I know there were discussions between Mr. Jan Wessels, Mr. Mlambo, and Mr. Fikile Mdlonto.
Okay, all right. Do you know whether the discussions were aimed at getting his approval or not necessarily?
I wasn't party to
You are
those
not sure about
discussions.
that?
I don't know.
Okay.
I know there were
Okay.
serious discussions, but I was never party to those
Okay,
discussions.
no, that's fine.
All right, may I take you to the email correspondence that seems to be relevant in bundle 1? Chair, I don't know if you still have bundle
Yeah,
1
of course,
accessible.
yeah.
Thank you. If I can start at page 788.
What's the page number?
788.
Okay.
Do you have it?
Yes.
Right. Now, there's an email right at the bottom, dated the 22nd of July. It's not clear what the actual content of that email may have been because it just has a disclaimer, but be that as it may. The email about halfway down the page, 2nd of September 2014, comes from Dennis Mlambo and is addressed to Celia Rienan. Do you see that?
I see that, Chair.
Right. So what Mr. Mlambo says is, I've just established that LMT does have a valid triple BEE certificate C attached. I'm baffled as to why it was not submitted as per your claim at this evening's meeting. I will request details from Stefan Nell about the pricing and proof of shareholding of VR Laser as discussed. Now, this appears to bear out the evidence of Ms. Malashlela as well as Mr. Mlambo that there was interaction between officials, maybe not yourself, but officials at DLS with Mr. Mlambo at head office level, correct?
I see that, Chair.
And that included Celia, Ms. Malashlela, from your procurement supply chain section, the head of that, correct?
Yeah, I see that, Chair.
And Renan Tubis, what was his position at the time?
He was COO of Combat Systems.
Yes. And one of the issues that was raised in discussion with Mr. Mlambo was the triple BEE certificate, because there was concern about whether the scoring of the triple BEE was done correctly and whether it may have favored VR Laser and prejudiced LMT. Are you aware that there were such discussions?
I can see I was copied on an email. I cannot recall this, Chair.
Yes. And then Rhiannon Tubis at the top of the page, in the email that you've rightly referred to as having copied you in, takes this further. And he says, as explained in this meeting, a formal process was followed to evaluate the proposals, etc. And then he refers further to all the bidders being given an opportunity 7 days to submit additional information. All this additional information that was received was within the 7-day period was then taken into account to finalize the scores. So the parties were allowed to give more information than what had originally been submitted in respect of triple BEE accreditation. Do you see that?
I see that, Chair.
Yes. And we know that VR Laser was allowed to submit a changed quote for price, but LMT was not.
I accept. We've already said
You've
that.
explained that
Yes.
earlier. Yes. Then Mr. Mlambo, who certainly doesn't seem to like to leave things unattended, replies on the 3rd of September on the previous page 787. He addresses it to Mr. Tubis and again copies in Celia Malashlela and Fikile Mdlonto. He was the group CFO at that stage, correct?
Correct, and he was also reporting to Fikile.
Yes, exactly. So he had a direct reporting line, Mr. Mlambo, to Mdlonto.
Correct.
Would I be correct in inferring from this that Mr. Mlambo was here making sure that his concerns were not just dealt with within the division, DLS, but were now being brought to the attention of his boss at head office level. Correct?
Correct, Chair.
Yes. And not only your procurement people like Ms. Malashlela, but also in divisional level, but also Jan Wessels, he was then COO of the group, correct?
Correct, Chair.
And also that you were kept informed, Mr. Burger, as CEO of the division.
Correct, Chair.
And then he sets out a number of issues that he describes as key issues. He says, as I did not have an opportunity to do a thorough study of all the tender submissions, I cannot categorically claim that the process was sufficiently objective and the confidence level is high enough to place it beyond reproach. He seems to be ringing an alarm bell here, not so. He's saying, I'm not satisfied on the basis of what I've been sent that this is necessarily compliant, correct?
Correct, Chair.
Do you remember actually seeing this email that was addressed to you?
Chair, I must have seen it at the time. I cannot remember. I cannot remember the content, or I cannot remember this.
Yes. Shouldn't you remember it though, Mr. Burger? In this sense, as CEO, you're having your juniors in the division, Ms. Malashlela, who's your most, in fact, she's the most senior person in the procurement section, not so. So she's been dealing with various issues such as triple BEE certificates and so forth. And Mr. Mlambo is saying, I've got queries about the triple BEE certificates, and then there's a response that is then provided to him that we've seen on the previous page from Renan Turbis. He then responds and doesn't simply confine himself to triple BEE, although it's clear he's not completely satisfied on that either. But he's saying, as I read to you now, nonetheless, the following are key issues that merit a serious review of the adjudication process and outcome. This must have been a serious alarm bell that should have triggered your interest and made you remember this sort of thing if you took it seriously.
Yes. The process, we were at that stage in the middle of the process. I was instructed by my boss, which was Mr. Salaji, to have 2 signatures on the motivation. That was Fakili Klontlu and Mr. Jan Wessels, to make the recommendation. At that time, during September, I was not interacting with Dennis Moslambo. And I was aware of the fact that both Jan and Fakili were constantly interacting with him. So I took this as obvious that they were considering his inputs. I say again, Chair, this I raised in writing and in meetings my opinion about the direction to go. I would have supported any decision that was made, this was not part of the process. This was now already lying at head office for months when this happened, when this issue arose. So for me, this should have been. If this was the problem, and I was Fakili with somebody reporting to me and speaking to him weekly about this program, I would think that he took cognizance of that before signing the recommendation. So yes.
But your feeling of comfort surely wouldn't have been justified, because you're here being copied in, and you say you must have received it. You've been copied in by the most senior person in the group. He's the group executive for supply chain. One of the witnesses, Mr. Nsepe, said that the term executive was wrong, that he was only a manager. But in fact, the delegation of authority approved by the board, in fact, calls him the group supply chain executive. But let's leave aside the label. He was the most senior official specifically tasked with supply chain management within the entire group, not so.
True, Chair.
And he is now flagging methodically, point by point. I'm not going to take you through all of them, but he's raising serious concerns that he's saying these are key issues that merit a serious review of the adjudication process and outcome. Did you accept the advice you were getting, or perhaps even instruction you were getting from Mr. Mlamba, that these are key issues that merit a serious review? Did you undertake that, or do you know if anybody else did?
I'm not aware of it, Chair.
No.
No.
And then he deals with capability. And one of the points he makes in the first paragraph is that LMT was the only one of the three tenderers that manufactured the same hulls under contract for Patria, but it obtained the lowest score on capability. DCD has never manufactured the same hulls, and yet it obtained a higher score. Now, I'm not wanting to go into a lengthy debate about whether Mr. Mlamba was right or wrong. He seems to be saying, why does LMT get such a low score when it's actually got experience of this? How can it get such a low score on capability, and DCD gets a high score even though it's never manufactured this thing? So how could it be given that? Now, your answer could conceivably be, well, LMT, although it's manufactured this sort of thing, can't be relied on. But whatever the outcome of that debate might be, seems to me to be unnecessary to go into. Mr. Mlamba is raising serious questions. There may have been good answers, like the one I'm speculating that you might give. But the point is, he is saying these need to be answered, and that needs to be reviewed. And yet that doesn't seem to have been done.
No, Chair. And I say again, at that point in time, this argument was escalated to DCO. So between Fakili, Jan, and Mr. Mhlambu, they were discussing this on a regular basis.
Yes. And ultimately, who signed it was Mr. Saluji.
Correct.
Yes. But are you saying that you just left it to head office, and even when you were alerted by head office's Mr. Mlamba to the fact that he was raising, rightly or wrongly, that he was raising issues that he was entitled to raise as Group Executive for Supply Chain, that needed this to be resolved, that you did nothing about it? Why
I did nothing about this, sorry, Chair, I did nothing about this email, correct?
Yes. And then he deals with a price difference. And he points...
I'm sorry, Mr. Kennedy. You say you accept that you did nothing about it. Why was that in circumstances where Mr. Mlambo was raising a number of issues of concern?
The reason for that is I was under the impression that there was a difference of opinion. And because there was a difference of opinion, this discussion escalated to a level higher than Mr. Mlambo. That was in my mind what was happening, and for that reason, I said these are unhappiness. We thought we gave a good answer. He now comes with different issues, and I have to admit, Chair, that, and I state that in my affidavit as well, that at that time, maybe I did not have enough patience with the situation. I was getting grumpy, and I was a little bit irritable. And I'm not saying that justifies it. I'm just saying that was this.
You just explain how.
Yeah, that was the scenario, and in my mind was for a person like Mr. Dennis Mlambo to say LMT could make this thing. I think he did not understand the challenges that I just sat with, where a supplier like a client like the United Nations formally told us, we will never ever buy from you again if you make hulls at LMT. So those were the issues I was dealing with at the time.
It seems to me that in a situation such as this, where the entities have been told these are the criteria that will be used to decide this competition between the two of you, or three of you, seems to me that you can only make the decision as to who gets the job on the basis of those criteria, and that it should not be something outside of that. Now, I want to hear what your comment is, because it seems to me that you knew certain things about LMT, and maybe a lot of other people within Denel knew certain things. But, and those things were influencing your attitude towards LMT as to whether they should be given this job or not.
True, Chair.
Now, to the extent that those were things that may have been outside the criteria that had been used by the scoring team, or whatever they are called, would it not have been illegitimate to use factors that may not have been part of the factors that the criteria that were announced as the criteria that would decide who wins?
Chair, the criteria that was set down by policy was new for us. It was not. We were not used to implementing those criteria. So we basically followed those criteria, and we came to an answer. My opinion at the time was, and I take note of Mr. Kennedy's position that it was a small variance. I take note of that. But my position at the time was, we strictly followed the prescribed rules. It gave a winner. And we did not use a reduced price. We did not use anything else. It gave a winner. Now, accept that it was by a small margin. The arguments that were put to me was, let's bend the rules to rather favor LMT. That was what the impression I got. Let's bend the rules to rather favor LMT because, for various reasons. They're part of us, we can, it's in-house and all those things. And those arguments, I tried to counter by saying, hang on, if you want to do that, understand the risk you are putting Denel into. And that was my position at the time. But, Chair, and I say this, and I've put it in writing then on emails, if Denel decided we're not going to, because of all these good reasons, the delegation lies with Jan above me, 3 people above me, for all these good reasons, let's go with LMT. We would have tried our best to make it work. No argument.
Okay. Mr. Kennedy.
I just want to raise one brief question on a point that you raised earlier, and that is that the reduction in price would not have made any difference in the sense that they already had the advantage in terms of the scoring. So this was, as it were, a bond seller.
That was my impression, Chair.
Yes. What I suggest is that that's not a correct impression. Because, in fact, if you hadn't allowed them to, or asked them and urged them in your angry conversation to reduce their price, then they wouldn't have reduced their price, and then they wouldn't have got the contract. So it seems to me to be absolutely crucial, the reduction in price. By reducing their price to 195 from about 260 million, that was pivotal in the decision. It wasn't an irrelevancy.
Sure, Chair. I'm not sure if I'm following. The issue here was we made a recommendation based on the previous price with the expectation to come down. Now, if they at that stage they made an unsolicited proposal, they had all the right not to say no. We made a mistake. It was the original 280 or 260. So from my perspective, then we would have been forced, probably if it would have been above the delegations, to come back and say this needs to go to the board, but the recommendation remains the same. In my mind, it would not have been different than supplier. The delegations would have changed.
Right. Now, just to complete our reference to this email, as I said, I'm not going to go through it point by point because it can be read in due course, and I don't think it needs to be debated. But one of the points Mr. Mlambo raises is price, the price difference of about 100 million. That's the price between VR Laser and LMT. Now that, of course, is their original quoted price of
Correct.
260 million. And he says the price difference between the VR Laser and LMT office is almost 100 million. In my investigation, I was informed by Stefan. Now, it's apparent from Mr. Mlambo's evidence that the Stefan there is not yourself, it's Dr. Stefan Nel.
Correct.
Right. That the LMT quote was based on factual figures, since LMT has manufactured the hull before. If Stefan is right, it would not make business sense to pay so much more. So he doesn't simply accept it necessarily as, well, Stefan Nel has said it, therefore I accept it as the gospel truth. He just says, this is what I've been told. If he's right, it would be crazy to go to VR Laser if you can get it for 100 million cheaper. So in other words, if Stefan is right, that would be an answer to your concern that the 150, 160 million that LMT offered, in fact, is a bit of a joke. It can't be taken seriously. Correct?
Correct, Chair.
Right? And then he says, and you agree it would not make business sense. Not so?
Correct, Chair.
Yes. And since LMT is a sister company, now by that he meant that by this stage LMT was already owned or subject to the share option. I'm not sure which, but it was now being brought into the Denel Group. Correct?
It was at that stage fully
It was already
owned by Denel.
Majority owned, not fully
share.
owned. Yes, but I understand what you meant by fully. I believe somewhat a DLS should have demanded the supporting evidence before assuming that LMT underquoted. Now, in fact, the belief that LMT underquoted was, it may have been shared by others in DLS, but it was certainly a feeling that you had, not so.
It did not originate from me, Chair.
It didn't originate from you.
No, it did not.
But it was, you shared that belief.
I shared that.
Right.
belief.
So you say, he says, I believe someone at DLS should have demanded supporting evidence before assuming that LMT underquoted. I believe that this anomaly warrants further investigation and validation. So again, it's a serious alarm bell. He's saying, well, you guys in the divisional level seem to be thinking that, well, LMT's price that is so much less than VR Laser, that can't be assumed in its favor because they underquoted. It's not a genuine price. He's saying, no, I, as the head of procurement, need to be satisfied, and you should have been satisfied. Where's your evidence for this? Not just Mr. Berger knows these things, or Mr. Terbus knows these things. He needs evidence. Would you agree that it's a responsible attitude on his part to be making sure, even if you're right, that decision can only be taken once the facts are established?
Chair, the question here is, what is he saying? Should we have increased the price if they said, oops, we made a little bit of a mistake? and re-evaluated. I'm not sure what the process would have been if they came back and said, "Oops, it can be a little bit higher than what we thought."
But does that matter?
No.
That doesn't answer Mr. Mlambo's point, does it? And that's what I'm asking you on.
No, it does not.
Right.
It does not.
Okay. And then he deals with BEE certificates, and he suggests that there was an unfairness in that. But what I'm particularly interested in is paragraph 5. Effectively, he's saying that there have been documents submitted by VR Laser on the ownership, and these raise suspicions as they do not specify the individual shareholders in person. Now, Mr. Mlambo's affidavit, he also gave oral evidence, but not in all its detail, in quite as much detail as the affidavit, obviously. He wasn't aware at that stage, as I understand his evidence, that in fact the Guptas were involved, or that something that could raise potential media speculation and controversy in the public domain. So it was an innocent question, but it was an important question. He's saying, well, they say that VR Laser is saying they're owned by somebody, and they say they're owned by particular companies, but they don't say who owns those companies. So he's concerned. He says the names Elga Solve and Crashaw Investments are silent about the identities of the real shareholders. There were no other documents. Now it seems that Mr. Mlambo may well have had some foresight, because as it turned out, it emerged later that in fact there was a Gupta link and so forth. Now I'm not saying that would necessarily have disqualified them or could have disqualified them, but he's not satisfied. He's saying there are all sorts of problems. Triple BEE certificates, one party has been given treatment different to another and so forth. Again, I'm not going to debate whether his opinion was right or wrong, but he reached this opinion. You don't dispute that Mr. Mlambo was trying to do his job in good faith?
No, absolutely.
Right.
Absolutely.
And it was in fact his responsibility to deal with this.
Absolutely.
And he had specifically copied in not just Celia and Rhiannon, Mr. Tubus and Ms. Malashlela, but also his boss, Mlambo's boss, and the COO, and of course yourself as DLS CEO.
Correct.
So he'd escalated.
Correct.
So he'd said, this is serious, these are key issues. And then his final paragraph, after the numbered paragraphs, he says, I trust that the details above clarify my reasons for not supporting the recommendation to appoint VR Laser to manufacture the hulls. Clearly he was of the belief, and it appears that he may well have been right, that he needed to endorse the recommendation. He also had to recommend the appointment of VR Laser before the group CEO finally approved it. That was part of his job, not so.
At the time, I did not see his. We've never had his signature for something that went to the group CEO on something like this prior to this. So we saw that as he needed to be consulted, his inputs needed to be given, and needed to be taken seriously, and then a decision was made. I must also say that the decision who to sign on the motivation was not my choice.
Right.
That was a decision made by the group CEO, Mr. Salaji, and he said those are the two people that must sign it.
Okay. Then he concludes his last sentence. Alternatively, the entire process must be revisited and conducted in a fair and objective fashion. Now, he's given evidence that he felt that this was not objective. He feels that you were subjective, that you, in fact, were, as his affidavit indicates, an oral evidence that no doubt you listened to, suggested to the chair that you were not objective. You were being subjective, that this was not sufficiently independent, and that he wanted the whole thing to be done properly in a fair and objective way. Now, obviously, you would disagree that you were acting subjectively. You've already given evidence that you believe this was a good business decision and so forth.
Correct, Chair.
But it's quite clear from this email that this was a serious matter, not so.
Correct, Chair.
Now, this was not simply a matter that was going on at head office level between different people at head office. because as we've seen, this email was addressed primarily to Mr. Turbis at your divisional level, correct?
Correct, Chair.
And in fact, you then replied to it. Presumably, you didn't leave it to Mr. Turbis to reply to because you realized the seriousness. You look at the email that starts right at the foot of page 785 to 786.
Correct, Chair.
Yes. And you then, for an entire page in your email, and I don't criticize you for this, set out some reasons why you say that VR laser should get it and LMT shouldn't. And then do you see the number of paragraphs 1 to 4?
Correct, Chair.
That sets out a number of your arguments in that regard. You then said, nevertheless, I'm convinced that VR laser is technically best equipped to execute this program. I also believe, given the recent contract performance of LMT, it will be irresponsible to place a contract of such criticality on them. Also take into account the effect the KSA order will have on them. What's the KSA order?
Kingdom of Saudi Arabia.
Right. So that's the same Saudi Arabian
That I spoke
order
about.
that you mentioned. Now, Mr. Mlamba comes back to you in an email at the top of the page 785 on the 4th of September, later on the same day. And he says, we're clearly not aligned in terms of the analysis of the data and information that I saw for the first time on Tuesday at the meeting I had with Renan and Celia. I think we should not exchange any more emails on the issue in question, as the resolution may be easier to find around a table. However, the following issues have definitely not been addressed. And so he deals with again, here 4 points: huge price differential, the issue of a conflict of interest, refuted any conflict of interest through submission of the document, etc., by the capability. He still has reservations in relation to this. And then after his paragraph number 4, he says, my contention is that despite being convinced of a fair and objective process that was followed by the adjudication team, and here his evidence explained that here he was really saying that he wasn't convinced, it was more that you were convinced. Let us appoint an independent assessor to corroborate your claim. It is also worth mentioning that you flouted the delegation of authority by not presenting the file for review to me before engaging Fikile, that's Mr. Mshlontlo, CFO, correct?
Correct.
And Jan being Wessels, COO, correct?
Correct, Chair.
Any transaction above 20 million must go through my office first. I'm beginning to have doubts that this was an oversight. Now, he there seems to be suggesting not only that you were being subjective and not objective, but also that you were actually manipulating processes. You received this email, did you?
Yeah, I remember.
Yeah. What did you do about it? Did you reply?
I felt that, no, his opinion was, let's resolve this round a table.
Yes.
That was his suggestion. I thought at the time there are clearly a difference of opinion. It is beyond my salary of decision making, and this should be escalated to the level of Mr. Saluji, Mr. Jan Wessels, and Mr. Klontlu, and they were all party to this, and for a decision. And
Now, did you? I'm sorry.
yeah, no, and that was my view. We
Right.
had differences of opinion, and
Did you write back to Mr. Mlamba and say that? Say, let's not have a roundtable meeting between us. It's above your and my.
No, I did not. I did not. Not that I can recall.
You see, again, it's interesting to note that Mr. Mlamba has taken the trouble, and he gave evidence that he did take this trouble for a good reason. He says he not only responded to you, but he also copied in Celia Malashlela, which was appropriate. She was your junior, but she was the head of supply chain at DLS, correct?
Correct.
So it was right that she should be kept in this loop, not so?
Correct.
And again, he copies in Mr. Mshlontlo and Mr. Wessels and Renan Turbis, and now for the first time, Mr. Saluji.
Correct.
So he keeps escalating it. He keeps saying, I'm not satisfied with this process. It doesn't look objective. It doesn't look compliant. You've ignored me. Now that I am engaged, I've now picked up these problems, and I need answers. Now, whether he was right or not to be satisfied with the answers you attempted to give, clearly he wasn't. Whether or not he was right to feel disturbed by your answers rather than reassured by your answers is neither here nor there. He was not satisfied. Now, he was telling his bosses, Mshlontlo and Saluji, I'm not satisfied. So you felt, well, then it must just be referred to them at head office and they must take a decision, correct?
At the time I felt we were running out of time. I'm prepared, and I say again, I said that in various emails, I'm prepared to accept any decision, but just take a decision. And it was with this very email, it was escalated to a point. So
I understand.
So that's how I felt, and then there were a lot of healthy discussions and arguments that happened after this. I was not party to and this is why I originally said I wasn't. After this, I didn't really have a lot of discussions with
Mr. Mlambo.
Mr. Malambo,
Yes.
but I know both Fikile and Mr. Jan Wessels did have.
Sorry, who and Wessels?
Mr. Fikile Mshlontlo and
Mshlontlo,
yeah,
right, and Mr. Wessels with Mr. Mlambo. Yes. Is it not correct that you, in fact, had a discussion with Mr. Saluji?
At the end, when we had the discussion, all of us, yes.
All of us being who?
The four of us, Fikile, Jan Wessels, myself, and
Sorry, you and?
the CFO and the COO and the group CEO.
So it was Mr. Saluji, Mr. Mshlontlo, Mr. Wessels, and yourself?
Correct.
Right. But not Mr. Mlambo?
Not himself.
You see, this is part of the problem that Mr. Mlambo has raised, and it seems to be an issue we need to canvass with you. I can fully understand your attitude that, well, we've got a complication. You've tried to persuade Mr. Mlambo. Mr. Mlambo has tried to persuade you, and you just can't see eye to eye on this. Not a personal antagonistic thing. It was a matter of on both sides you've accepted people being bona fide and trying to do their job. You haven't persuaded each other. So now how do you break this logjam? You go to the bosses, because after all, the delegation of authority ultimately vests the final approval in Mr. Saluji.
Correct, Chair.
And now Mr. Mlambo regarded his own approval or recommendation as being vital, but let's leave that debate aside. I think we've touched on that already, and the delegations of authority can be looked at. But so let's accept for a moment that your position, at your level with Mr. Mlambo's level, you've reached a logjam. It's got to go higher.
Correct, Chair.
Now, it seems to me to be significant that Mr. Mlambo was not part of that meeting. Now, I'm not suggesting that you should have told Mr. Saluji, your ultimate boss, how he should run a meeting. But I'm just asking you to comment on this, because the chair ultimately has to look at whether this process was properly done and carefully considered by management, particularly where it's in the context of public controversy about state capture and so forth. The chair may need to be satisfied that this was a truly genuine, bona fide, good faith type of transaction, not designed to favor people like the Guptas because of their political connections and so forth, but this was a genuine bona fide thing. I just want you to comment on my concern. Mr. Mlambo has been playing his role, raising all of these concerns, and yet he seems to have been left out of well, we know he wasn't part of that meeting. Do you know why not?
I have got no idea. It was not strange for me that his name was not on the motivation, because that was the way it was done previously
Yes.
for orders above 50 million. Obviously, orders between 20 and 50 million, he had to sign off, but orders above 50, it was the CFO and the COO that needed to recommend. And in my mind, the CFO represented Mr. Dennis Malambo.
Right. Sorry, the
The
CEO represented Dennis Mlambo.
the CFO,
CFO represented Mr. Mlambo.
correct, because he was reporting to him.
And the CFO had in fact been copied in on these emails, admittedly.
Yeah, I don't even see his name here.
Certainly, sorry, the CFO was Mr. Mshlontlo.
Yes,
Yes, on page, the email at the top of page 785, I see Fikile Mshlontlo after Celia.
Oh, yeah, there he is, sorry.
Celia
Yes,
Malashlela.
correct. Yes,
So it does seem that Mr. Mlambo included him as one of the people to whom this was copied.
correct. But to give you credit, Chair, that if I was, if this was such a big issue, because subsequent to this email, there were many meetings at head office, which I was not party to.
Right.
And many visits to LMT and to whoever, and I was not party to that.
Yes.
And if this was so controversial, I would probably have, if I was in the shoes of Mr. Mkhlontlu, I would have probably said, Dennis, come with me. I take that view, or that accept that point. But the fact of the matter was, it was at a stalemate. It was escalated. Everybody that was there were represented by their bosses at least, and it was signed off.
Right. Now, can I take you now to a further email at page 791, still in bundle 1, the same bundle?
791.
Yes. The correspondence we've just been looking at was dated the 4th of September, and this one on page 791 is dated a few days later, the 9th of September 2014. Do you see that?
I see that, Chair.
Yes. And this now is sent by Mr. Mlambo to Mr. Saluji. He's the actual addressee together with Mr. Mshlontlo and Mr. Wessels. Now, he says, I've managed to review DLS's submission pertaining to the above-mentioned subject. The following issues paint an unacceptable picture from a process, fairness, and objective point of view. Now, of course, those terms have particular relevance when you look at the constitutional requirement that there be a process, that there must be a system, and you must comply with your system. It must be done in a lawful, fair, and objective manner. And he points out that there are a number of defects in the process, which he obviously regards as being serious. In paragraph 4, he says, in the submission, it is claimed that LMT's quote is too low and unrealistic. Now, that would be the submission that was prepared by Ms. Malashlela that you signed for purpose of submitting to head office to get the GCEO's approval. Correct?
Correct, Chair.
And in that memorandum, that point had been made, that the LMT quote of about 150 or 60 million was too low and unrealistic. Correct?
Correct, Chair.
Right. And then he says the difference between LMT's quote and the VR laser quote is almost 100 million. After questioning Stefan Nell on the accuracy of his quote, he offered to come and present the facts to demonstrate that it is based on realistic quotes. Furthermore, he claimed LMT had made the hull before under Patria's contract. Then he says in paragraph 5, in my meeting with Stefan Burger yesterday, so you actually had a meeting with Mr.
Correct,
Mlambo.
I see that now, yes.
It wasn't just emails, correct?
Correct.
Right.
As was suggested in that last email of his.
Indeed. He says, that's yourself, Mr. Burger, indicated that VR Laser had offered to reduce the quote from around 262.4 million to 195 million, exclamation mark. That clearly is something that is worthy of emphasis. He He says, doesn't that tell a disturbing story about the initial offer? On the basis of these findings and other facts, it is my considered opinion that the submission from DLS be rejected. Since LMT has the capability to make the hull, this issue should have been discussed before going out on tender. Now, again, I can't expect you to defend Mr. Saluji or Mr. Mshlontlo in their actions. But what I'd like you to comment on is this. Mr. Mlambo's evidence suggested that you effectively put a lot of pressure on Mr. Saluji and made a whole issue about the very point you raised just now. Urgency. We need this urgently. And LMT's offer can't be taken seriously. They've underquoted and they've got technical problems and so forth. And all of that you presented to Mr. Saluji and persuaded him in a way which had the effect of not only undermining Mr. Mlambo's position as head of supply chain management, but importantly, probably most importantly, he is saying this as your expert in supply chain management. I'm telling you that this has not been done fairly, properly, objectively, and correct from a process point of view. And he said, I just smelt a rat. He said, I don't believe that this was being done objectively. This was being rushed through. And arguments about things being so urgent were being put above the importance of procedural compliance, legal compliance. Do you have a comment about that, particularly to the extent that that criticism is directed not only at them, but at you personally?
Yeah. Firstly, the Chair, the opinion of it being illegal is a surprise to me at the time. It never crossed my mind. Secondly, this very strong letter, I wasn't party to it. I didn't see it, and it's news to me. It is. We were running at a schedule, and this was getting late, and in the day for approval of it, especially with regards to certain milestones like technology transfer and so on. The long and the short is I felt strongly that VR laser, given everything, is in all probability the better decision, given everything from a technical and a risk perspective. Sorry, I've got lots of respect for Mr. Dennis Malambo, and he understands the processes and the procedures and the National Treasury requirements much better than me, for sure. But unfortunately, he did not create over years a scenario where it is easy to find compromises. The frustration levels were very high.
Frustration on your part?
From the divisional level, it was high, and it wrongly, and I'm not trying to defend it, but it at that time it was felt that he is making life difficult for obvious decisions. So yes. But I take your point. I'm not going to argue it, but at that time there was a level of frustration, yes. And this is why I did not go and see on my own Mr. Saluji and lobby with him, if that is the insinuation. There was a discussion. I did put over my points with enthusiasm, but both Jan Wessels and the CFO were having discussions on a regular basis about these matters with him.
With Mr. Saluji or Mr. Mlambo?
Mr. Malambu, Mr. Wessels, and Mr. Mklontlu had regular discussions, regular. And after this, and you can see here, this was now escalated. It was no longer on the level of the division and group supply chain. These things were discussed, and I put my arguments, the very same ones as articulated here, as I said earlier, I put on the table there, and I was prepared to make compromises, but I was really scared about the safety critical item like a hull, and that is as simple as it was.
Right, and also delays.
Of course, I was
Yes.
concerned about it.
Can I just debate with you the latter aspect of delays?
Yes, sir.
You see, I understand from your evidence, and in fact the evidence of some of the other witnesses and some of the documents, suggests that there was frustration on the part of people like yourself, that there were delays and that delays were unacceptable and should be avoided or minimized. I accept that that could be a legitimate concern.
Yes,
What
Chair.
just seems to me to be a bit strange is that in the greater picture, whether if there was a delay in relation to what Mr. Mlambo was suggesting, as you've accepted in good faith, that these issues need to be investigated and possibly a fresh process should be undertaken in order to comply with the requirements of the law and of the procurement processes. If that had taken place, it wouldn't have meant a delay of many years. Correct?
Correct, Chair.
Let's assume for a moment, and Mr. Mlambo has not said that it was necessary in this case that, particularly under this supply chain policy at that time, that you had to do anything other than a request for offers, a request for quotes. It wasn't necessarily going to be a fully open public tender advertised in the media, etc. It wouldn't have taken all that long. So I can understand when you say that you were frustrated with Mr. Mlambo. You've accepted he was in good faith. You accepted that he was entitled to come to these opinions. You may have disagreed with him. But he, and you've suggested that he was being difficult, but not in bad faith. It was just frustrating to your intent to get the ball rolling.
Correct.
But in the bigger picture, if you had humoured Mr. Mlambo or complied with Mr. Mlambo's request, and the same, of course, applies to Mr. Saluji and Mr. Mshlontlo, and we have had to deal with those questions with them, it wouldn't have delayed the Hoefyster project by much in the greater picture. We have before the Commission facts as to the seriously disturbing delay in the project, which goes into, we're talking about more than a decade. So I can understand you may have been frustrated with that as well, and that may not have all been your responsibility and so forth. So even if one accepts your desire to expedite things, hurry things along, firstly, wasn't it required in terms of the law? Wasn't it required because your expert within the group, Mr. Mlambo, was saying we need to do this? And surely it would have been possible to do it, where in the bigger picture, any delay was not going to make another decade on top of what was already there. Any comment on that?
Yes, I would like to put the slip in perspective. A lot has been said about PBL-A and PBL-1, and they do not know if in the next 3 years PBL-1 will be achieved. How that works is there is not only one PBL-A and one PBL-1 per variant. There is a build-up of PBLs.
Sorry, but why are you raising that in
sorry,
relation to my question?
I'll get to that point.
Please.
Sorry, I'll get to that point. In 2013, we already reached the subsystem level PBL, where we could go out with the manufacture of the hulls. In 2016, Armscor granted PBL1 on the combat system with certain conditions. That was in 2016, 4 years ago. So we were running at a schedule with the expectation PBL has, well, in 2016, it was building up to it, and it was achieved in 2016. Subsequently to that, I'm told that Armscor took the decision that those conditions are not, were not met or were not favorable, or I don't know what the reason is, and there's no longer now a PBL1. Now, this is extraordinarily disturbing, and I think anybody should be disturbed by this. I also want to put it that the Malaysian order was running on, probably more complex than Hoefyster, was running on schedule, was running within budget, and was running within the technical performance. So we were used to performing according to the program plan.
Right.
And that is why I was jittery and getting frustrated, number one. Number two, the hulls were a separate line item on the contract, which meant that we were selling the hulls. Every hull that was made, we would sell, Armscor would come and accept it, their program management, their quality, as well as Denel land system quality, they would sign it off, and Armscor would then buy the hull, and we would get the money for the hull. So it was in my interest at the time, these were one of the very few separate line items, get the hulls out and get them into production. So Chair, it is not correct to say, but the program is a decade late, what does it matter if there is another 3 months taken? I just wanted to clear that perception.
Right. Okay.
But
Yes, but I'm not sure that I understand. Mr. Kennedy's point is this. When you and other people may have thought or may have taken the view that Mr. Mlambo's issues were going to cause a delay, or that he was delaying the process. Mr. Kennedy is saying, but the truth of the matter is, even if you had to redo the process but do it properly, if what was required was to just send out a request for proposals or whatever in regard to 2 entities or 3 entities, it wasn't going to cause a delay, the kind of delay that you should really have been concerned about. Because, and I'm now adding what he didn't say, it must have been possible to do that within, I would imagine, even 2 weeks, because these were entities which had already worked on this thing. They were not going to start afresh. So how could a period like 2 weeks really be something to complain about?
Chair, no, you are right. And this is September. It was finally approved in November, I think it was, thereabouts. So you are correct, Chair. The time was probably there to do that. In hindsight, you are right.
Yes.
The point I was trying to make was I could never, as a CEO of a division, acknowledge that schedule is not important. It always was, and it always will be. But in the greater scheme of things, and it was only signed in November, it wouldn't have mattered.
Yes.
You are correct.
Yes. Mr. Kennedy?
Yes, thank you, Chair. Just to complete my questions on this issue, Mr. Burger, of course, it's always possible in the real world out there, especially in South Africa these days, that parties who are unhappy about the outcome of a procurement process could take you on review in a court process, not so?
That's true.
Certainly, counsels such as myself and my learned juniors, in fact, have
Are always ready.
We're always ready. Our phones are on. Sure. It's a growth industry, as it were. Now, and of course, the courts are burdened with a huge load of these things. You're aware, at the time, a chief executive officer, that there are risks if you do something unlawful, let alone unconstitutional. You can be taken on review. Now, this could have happened here, not so?
You are correct, Chair. I concede to that. But in my mind, at that time, we sat with the group CEO that needed to sign this off. He was the boss of the organization, the person that signed the delegations of authority. In my mind, I didn't have any hesitation to think that if he signs it off, there is something funny. So in my mind, I didn't see it as being unlawful. But I listened to the commission, and I accept that the rules have changed. And
well, for some time, yes, yeah. Long before 2014, yeah. This type of litigation has been going for quite a while. But let's leave that aside. I'd like to explore briefly, if I may, Chair, with the witness, this issue about, well, if the group CEO signs it, then you're sure that there can't be anything wrong. What I suggest to you is that that's a very passive approach to your duties at that stage as CEO. You were CEO of the division. In fact, you were very keen to have more powers and authority given to you at division level in terms of the decentralization that you preferred, not so?
Correct, Chair.
Now, I see you smiling. Are you seeing a bit of a logical inconsistency? But I'll give you an opportunity to answer that. May I just complete the question?
I think he will concede it.
I think so too, but what I want to put to him, if I may, Chair, I'm not going to belabor the point, I hope. What I'm suggesting to you is that part of your, and here I'm not Mr. Saluji's defense counsel, and I know there have been some allegations even in your own affidavit about Mr. Saluji being given special treatment, and so I'm not going to go down that route. But at a level of not just law but good management practice, when you are the head of a divisional unit, in this case DLS, and you have to take certain steps in your division, and then whether you like it or not, you have to send it up for approval to the group CEO for his approval, in this case Mr. Saluji. Isn't it your duty to be ensuring that Mr. Saluji is protected and informed, in the sense that you shouldn't send anything to Mr. Saluji for approval unless you have ensured that there's been proper compliance? Rather than saying, well, let's see if Mr. Saluji approves it. If he does, as you put it earlier, well, he's approved it, so I didn't see anything wrong with it. Surely it was incumbent on you to see whether there was anything wrong with it before you sent it, because you were recommending it to Mr. Saluji for approval, not so?
Correct, Chair. And under the normal run of things, you're absolutely correct. It is my responsibility.
Yes.
But the point is, this issue was escalated. Everybody was aware of the issues. It was not news to...
Aware of
the issues that was
the
issues that was put on it. It wasn't news to anybody, and that's why I say, regardless of that, both the COO, the CFO, as well as the group CEO, decided to accept this.
Yes.
It was something wasn't being kept away from him. He knew everything.
Right. Now, if we accept your evidence earlier that you were at the time unaware that there was any breach, but have since realized that there was a breach, at least in respect of negotiating a lower price with VR Laser, would you accept that Mr. Mlamba is entitled to say, he raised all of these issues, as you say, with his bosses, as well as with you. They effectively, in his view, ignored it. They didn't come back to him. They didn't say, well, Mr. Burger has said this, and what do you say about that? There was none of that. Instead, he finds out later that Mr. Saluji has signed, despite the fact that Mr. Mlamba had raised all of these objections. And so Mr. Mlamba has suggested to this commission in his evidence, well, I don't understand this. It actually seems to compound my fears and perceptions initially. There's something funny going on here. Mr. Burger is acting subjectively. Even when I raise with him concerns about compliance with the legal requirements of the procurement process, I get vague answers from Mr. Burger. That's what he's effectively saying in his email. Whether he's right or wrong, leave aside for a moment. And he says, and then it's escalated to head office. There's a discussion not involving me, Mr. Mlamba, but Mr. Burger then has a fast track to have a meeting with Mlamba's superiors. He's not invited. Mr. Saluji then just accepts it. And what's happened to my objections, my being Mr. Mlamba's objections? There seems to be something funny about this. Do you understand
Understood.
his perception?
Understood. But he has also, in his evidence, said that he only found out, I think, 5 months after the event that this was done. An email was written, sent to him. The email is at the investigators that informed him of the meeting a day after it was signed. So,
And its outcome?
yes,
Right.
a day after it was signed. So there was no, we were not trying to hide anything from him. He was informed.
But are you suggesting that he's concocting evidence and deliberately telling an untruth to the commission when he said he only found that out later, much later?
I cannot say that, Chair.
Okay.
He might have forgotten.
Okay.
But,
Well,
but
that's a generous attitude on your part, Mr. Burger.
Okay. Shall we take a short break? We are at 29 minutes past 4.
Yes, thank you, Chair.
And subject to everybody being happy, Mr. Becker and your council, I propose that we continue until maybe about 5:30,
Thank you, Chair.
or thereabout, before then we adjourn. If at that stage the feeling is that justice hasn't been done to the issues that Mr. Becker must cover, then another opportunity will be arranged for Mr. Becker to come back.
Yes.
Is that fine with you, Mr. Becker?
100%, Chair.
And your counsel, that's fine with? Is that fine? Yes, okay. Let's
Thank you,
take
Chair.
a short adjournment now, and we'll resume in, shall we say 10:02? So a 10 minutes break. Not 10:02, 22.
22, yes.
22.
Thank you, Chair.
We adjourn. And let's continue.
Thank you, Chair. May I proceed? I didn't quite hear you.
Oh, let us continue.
Yes, thank you, Chair. Mr. Berger, we've dealt extensively now with the platform hulls contract, and I think that we've debated it as far as we, from the legal team's perspective, needs to say for one point, if I may just ask. The price reduction by VR laser that you were able to get in a phone call with a bit of an angry tone resulted in a reduction from 262 million, that's the actual total value of the bid that was put in by VR laser, to 195 million, correct?
Correct, Chair.
And you've already commented about why you felt that they shouldn't have tendered so much in the first place. It does seem curious that they were persuaded so easily, as I've put to you earlier. The question that one of my learned colleagues has just asked me to put to you, and I do so because I think it is a valid question. You may have a valid answer to it. We'd like to give you this opportunity. Is the reason why they were why they were prepared to come down so suddenly and so easily and so substantially in price that they were told that they could make this up in a single source supply contract?
I reject that, Chair. At that time, there was no inkling about a single source contract.
Okay, well, then let's move to that very contract. That took place the next year, is that right?
Correct, Chair.
Now, what I'd like to find out from you is how it came about that this contract was in fact negotiated and then granted. Who came up with the idea?
The then Group CEO, Mr. Saluji, called me to his office one day and informed me that we should supply him with a MOU. I am not sure if the word MOU was used, that looks at single sourcing wherein the rights of Denel is protected. I then went to the division. I had a discussion with Mr. Rienan Tevis. I asked him whether he thought this was a good idea. His initial response was yes, mine also, by the way. We, however, decided let's within the division check if the engineers also think it's a good idea. There was a study done by the engineers, and it was also discussed at on an executive level. It was minuted. It is very clear that in the minutes, and I haven't got it in front of me, but that a MOU must be produced with certain conditions on it for signature by the group CEO, and so we did that. The first MOU that came out from the team had my name at the bottom. I asked that it be changed to Mr. Saluji's name. I had a discussion with Mr. Saluji, and he said, no. He will sign the approval page, and I must sign the document. In the next iteration, he said, no, I must add Mr. Zwelaki Nsepe on the document. In the next iteration, he said, no, I must also add Mr. Jan Wessels on the motivation, and the document was presented.
The question was who initiated that? It wasn't your own suggestion, it was Mr. Saluji.
Correct, Chair. Sorry, it's a long-winded answer, but correct, Chair.
Sorry, I'm not trying to be sarcastic. Yeah. Is it not curious, though, that this sort of suggestion should have come from head office? After all, you had for some time been the CEO of DLS. And Mr. Saluji presumably would rely, although it was to an extent a centralized model, there was a measure of decentralization in that not every decision within DLS was taken at head office level, correct?
Correct, Chair.
Yes. Did you find anything curious about the fact that it came from Mr. Saluji rather than from within your own division?
Chair, I write quite a lot about my relationship with Mr. Saluji in my affidavit.
You do, yes.
Mr. Saluji made it very clear that so-called political decisions and certain marketing decisions, he's better suited to take those decisions.
Marketing or market decisions?
Marketing.
Marketing.
Marketing
But
decisions.
this was not a marketing decision.
No.
Correct?
Correct. But also certain political decisions. He has, in the past, given me many instructions to say certain suppliers are politically well placed, and we must please support them.
And did you do that?
One of the suppliers he mentioned was VR Laser before the 2014 approval.
Even before the 2014 approval for the whole
For the
platform
whole-
contract. Did that have any bearing on your enthusiasm for VR Laser for that contract?
My answer to him at the time was, VR Laser is one of our better suppliers. He shouldn't worry. It is common knowledge that they will get work, so relax.
So you were happy to give him comfort in expecting that you would ensure that VR Laser would get a fair lot of work?
I was convinced through normal processes they would get a fair amount of work.
Yes. Now, how did you find that request or instruction from Mr. Saluji even before the 2014 contract was awarded? Did you feel that it was a proper one?
Chair, our relationship was, although I had a lot of respect for him, he was a very dynamic group CEO. Our relationship was strained, and I think he had to break the decentralized model. And in breaking the decentralized model, he probably needed to cut me down to size a little bit. But our relationship was a tense one, and given his numerous occasions where he said, "You keep your nose out of political matters. That is my domain. Certain things are more important that you won't understand." I didn't like it, but I accepted it as the normal run of the business.
I assume that you would agree that political matters may have a range of different meanings and interpretations. Correct?
Correct, Chair.
And one narrow one would be that to the extent that this is a state-owned entity where the cabinet member responsible for public enterprises is the shareholder in Denel on behalf of the state, and there has to be accountability by the board and the group CEO to the minister, that would involve legitimate political interaction, correct?
Correct, Chair.
And in that sense, if Mr. Saluji was saying to you, leave the politics to me, Mr. Saluji, that there would be nothing wrong with that, correct?
Absolutely not.
Yes. In fact, it would make sense not to have a divisional head like you dealing with the minister unless there was some reason to report to the minister that there's something seriously wrong going on, that you
Correct.
couldn't resolve it internally. Right. But it sounds to me as if he was saying something a bit more than that, not so?
He was suggesting that certain divisions or certain suppliers were politically well positioned.
Well positioned to what? Get favourable treatment, get preference in the allocation of or award of contracts for business.
His opinion was it'll be good for Denel to place contracts on them.
Because they were politically connected,
Correct.
not because they were necessarily the best supplier to do a good job. Not so.
Yes, hopefully both will be true, but yes.
But it certainly wasn't just the one. As I understand your evidence, your perspective and your contention before the learned chair is you looked at it from the point of view objectively, although Mr. Mlamba questioned that. You've assured the chair you were looking at what was in the best interests of Denel, regardless of political connection.
Correct.
Is that your case?
Correct, Chair.
Right. Now, obviously, if it was simply a question of saying, well, we want you to do a good job, Mr. Burger, make sure that you get the best product from a quality point of view and the best price and so forth, that would have been a legitimate expectation, correct?
Correct, Chair.
But you knew that already, that you knew as your function.
Obviously, correct, Chair.
But again, obviously, he was suggesting something different. He was suggesting that in award of contracts, that VR Laser, because they were politically connected, should be given a preference.
Correct, Chair.
An undue advantage because they were politically connected, not because they were necessarily the best company. Is that how you understood him?
Correct, Chair. I however, would not have supported something that did not correlate with my belief in it being the best and not in the best interest of the business and the operations.
But it's interesting your reaction to Mr. Saluji. It's not to say, I would never do anything that was not in the best interests, boss. It's to say, don't worry, boss, and I'm paraphrasing you, and if I'm oversimplifying or distorting it, please, you'll get an opportunity to correct me. You seem to be saying, don't worry, boss, they've been getting a lot of work already. You don't have to worry, they're still going to get lots of work.
Sorry, if you read my affidavit, I said, I believe that VR Laser is in the best business in their niche area. From that perspective, I am anticipating they will be getting work, and therefore, for that reason, your concern is covered.
But Mr. Saluji's concern, it seems, wasn't simply that they should get a lot of work because they're good. We've debated this already. His concern. So what you seem to be saying is when he was suggesting something improper to you, you came back and you said, well, don't worry, they're going to get it anyway. For a good reason, not for the reason that you're telling me, boss.
Yes.
Not so.
If this was the first incident, then it would have probably raised more alarm bells. But similar instructions was given with regards to N4 in the past. It was N4, which also manufactured Caspers for us.
Was the same remark made that they should be looked after because they're politically connected?
Correct.
And when was that said to you by Mr. Saluji?
Probably, it was before that, probably 2013, I would imagine.
Right. And did you react to that? Did you respond to him when he told you that?
I didn't officially respond.
And unofficially?
N4 did get work.
I'm sorry, they got work.
They got work, but
I'm asking you about your response to Mr. Saluji, not whether or not they got work.
I hear you,
say you didn't
response,
officially respond. Did you?
What I said was, I hear you, sir.
I hear you. You didn't say to him, I'm sorry, Mr. Saluji, I don't mean to disrespect you, but I have a real problem with that request or instruction. I'm afraid I'm going to decide things to the extent I have authority on purely proper grounds, not because of political connections. Now, that might reflect a naivety on my part in that you were obviously some rungs below Mr. Saluji, but wouldn't that have been the appropriate response?
Let me answer it in this way, Chair. I still, today as I sit here, I've got no regrets that I supported the whole manufacturing at VR Laser. However, the fact that I just accepted Mr. Salaji's instruction, I do regret. I think the responsible view would have been something doesn't sound right here.
And you could have done that diplomatically.
Yeah, I could have.
And
I did
hopefully have kept your job. I mean, presumably if you had said something like I've suggested to Mr. Saluji, I'm afraid that if you're going to ask me to favor anybody, however good or bad they might be, for a reason not that they're good, but because they're politically connected, I'm afraid I can't do that. If he had then charged you with insubordination or a failure to comply with an instruction, surely you would have been able to say, well, that wasn't a reasonable or lawful instruction.
Correct, Chair.
And the law, no doubt, would have supported you on that.
Correct, Chair. My dilemma that I sat with at the time was the thing he gave me instruction on was something I wanted, and that is the dilemma. And
Yes.
And you are correct. I'm not arguing it, and in hindsight, it would have been so much easier. But
Well, it might not have been easier, but it might have been easier in the sense that you wouldn't have to be facing these questions under the glare of television lights and in a judicial commission chaired by the Deputy Chief Justice. So in that sense, I accept that. But yes. And of course, Mr. Saluji must give his version as to whether or not this was said in the context. Can I just go back to the other reference that you gave? The other example you gave was N4.
Correct.
That he'd asked you to favor for political favoritism reasons. In that case, were you also keen to support N4 in business because of them being superior, like you regarded VR lasers being superior?
we manufactured Caspers at many suppliers, and they were one of our suppliers. So it wasn't in my mind, a big deal, and it wasn't such a substantial contract in any case. So that wasn't in the years that would have followed. They would have received work in any case.
Can I ask you this, apart from how you could perhaps in the ideal world and with the benefit of hindsight have responded to Mr. Saluji, again with the benefit of hindsight, should you not have considered perhaps reporting Mr. Saluji? You know that although it may be better on paper than in practice, the law provides considerable protection for whistleblowers. And would it not have been possible for you to have reported, for example, to the Minister of Public Enterprises or the Public Protector or Parliament or somebody like that, or the chairperson of the board, whether or not he may have been amenable to such a report may be debatable, but did you not consider that possibility?
It would have been the right thing to do.
Yes.
Chair, but the dilemma I was facing was our supply chain processes were horrendously slow. If I took the number of orders that needed to be placed and I divided it with the days available, it would have taken forever under normal processes. So, firstly. Secondly, I already expressed my opinion about VR laser and the capability, and in my mind, and in the past, we used to have a lot of single source suppliers. So his proposal, even though he said they are an important supplier, they're a connected supplier, please form a single source agreement with him. That coincided with my ambition to streamline processes. So that was the dilemma. And if I reported him, I would have gone against something that I thought was good for the business and would streamline the business. And so, but in hindsight, I should have done that.
Yes.
I should have done that.
Your last argument about how it suited your business objective, as you would put it, for good business reason, it does suggest, perhaps, that you're arguing that the end justifies the means.
Chair, I'm not saying that, Chair. I'm not saying that.
But can't one read into it that exactly that?
Yeah.
If you're not saying that, what else is it?
Yeah, I was naive.
I'm sorry?
I was naive, Chair.
You were naive.
End was the end that you wanted to.
Yes.
Yes, I was naive, and it was an objective I pursued. And just to put this in perspective, if this thing came from the Nell Lane systems, it would have been a totally different approach. We would have written a position paper, given the pros and cons, given all the arguments.
Yeah.
We would have presented it at the exco of the DCO or the CEO, and he would have said, right, this sounds good, investigate, continue, and give me feedback. That's how that would, if it was initiated by the Nell Lane systems. It didn't happen like that. But I thought it was a good idea, and that I cannot.
Okay. On the last point, can we just?
Sorry, and this is for me a very important point to make. Sorry, Chair, my apology for interrupting. If the insinuation is, I knew, as an example, state capture or corruption was at play, and therefore let's support something that will promote state capture or corruption, then I would have, regardless of what the situation for DLS would have been, I would have said, no, we can't do that. I mean, in my mind at that time was, this is a connected supplier, and it's important. They are a transformed supplier. It's important to support them, and the way you should do that is get a single source agreement in place.
But Mr. Saluji was not making his request or giving you his instruction to favor VR Laser simply because they happen to be black owned and to advance triple BEE. As I understand it, the whole point that he was trying to stress is not that they are black owned, but that they are connected politically, and they must therefore be favored.
They are politically an important supplier.
But politically important must mean they are connected to politicians who want us as a state entity to do what they expect, which is to give their buddies contracts which they might not get if you follow the normal processes, correct?
Correct, Chair.
Right. So I just want to test, I mean, I don't want to go into a definition, a debate about the semantics about what state capture and so forth means. But you've said you would have reacted, you would have resisted an instruction if you had known that this actually had elements of state capture and corruption, correct?
Yes, yes. Yes, Chair.
But of course, the term state capture had not been conceived of at that stage. It came about much later. And of course, the corruption specific to the Guptas also only became revealed only much later.
Correct, Chair.
At least in the public domain.
Correct, Chair.
Did you have any idea at that stage who now owned VR Laser? Presumably you did, because you were doing a lot of business with him already.
Yes, by 2015, I think it was already in the public domain.
Right.
The full extent of that came known to me in 2016 when
Yeah.
I received an email from Celia Malashlela.
Right.
That's when everything sort of dawned.
Yes. Now, I don't think we can reasonably expect you to have had advanced knowledge of all the facts that have come out over time. And in fact, this commission has served the purpose, amongst others, of actually revealing a great deal of facts that the public may not have had before, and media may not have had before. It's one, no doubt, of the reasons that the President decided to appoint the commission in the first place. But at the time that you were dealing with a single supplier contract in 2015, you knew already that there was concern on the part of Mr. Mlambo about Denel being satisfied as to at least having knowledge as to who the true ultimate shareholders and beneficiaries of VR Laser were. That had arisen already in the Hoefyster contract, not so.
During the Hoefyster contract, I didn't particularly pay attention to that.
But my question was not whether you paid attention.
Yeah.
He had raised it. We saw that in paragraph 5 of the one email we saw earlier, not so, where he says, all that they have said when you guys at divisional level had requested disclosure of who the shareholders are, all they give is the shareholders in VR Laser are 2 companies. And I don't know who's behind those companies. So already then, whether he knew or not that the Gupta connection existed, he was concerned about that, as he was entitled to be, not so.
True.
Right. Now, so when the single supplier contract came up, you must have been aware, then you've said, you think that already it was in the public domain as to who owned VR Laser, ultimately.
Yes, Chair.
Being the Guptas.
Being Salim Essa.
Being Salim Essa, who was connected to the Guptas. Correct?
Yeah. In 2015, I did not realize the strong association yet.
Okay. Were you aware then, or can't you remember, that Mr. Singala was a director of VR Laser at the time, and that he was a son of one of the 3 Gupta brothers?
If not then, it must have, I think it was shortly thereafter.
Yeah.
That I started becoming aware of him. I think I started becoming aware of Mr. Singala around middle of 2015.
Right. So let's accept your earlier indication that if you had known when Mr. Saluji gave this instruction to prepare a motivation to enter into a single supplier contract with VR Laser, you at least knew that there was a particular shareholding in VR Laser, correct?
Correct, Chair.
And you also knew that why Mr. Saluji was raising this was precisely because he expected you to be giving business to VR Laser because they were politically connected. Correct?
Correct, Chair.
Yes. Did you ask him, did he tell you, or did you just guess for yourself how the political connection came about? How VR Laser were politically connected and with whom? Could you guess, or did he tell you?
No. He did not inform me whatsoever.
Yeah.
At the time, it wasn't. During that discussion, I'm not sure. I can't remember exactly if I've met a person like Salim Issa. I think I did at the time, but so I knew about him I think I started to know a little bit later about Mr. Singala, but what was going through my mind at the time was, and that is why I also told the story about what happened in India, is that I don't know of any wrongdoing, that these guys have done something funny. So if a company, and I also didn't consider at the time too much focus on who's the owner of a company, apart from proper triple BE and so on. What was for me of importance is how good a company it is and how good they can perform. I was very sensitive of judging people based on newspaper articles.
Right.
And that came from the whole India debacle. So my opinion was, if somebody did something wrong, send him to jail. If a company gets blacklisted because of wrongdoing, close the company. But do not react on something that is written in a paper about.
I understand that, Mr. Berger. What I'm interested though is more than that. I can understand you do not want to take decisions based on rumors and speculation and gossip and so forth. And the
Correct.
media, we know, with great respect to the media representatives who are here, who no doubt doing their job in good faith as well. We know that often the media is either wrong or may carry something because people are feeding them stories that may spread false information out there. I fully understand that, but I'd like us to focus rather on what you did know from Mr. Saluji. So whether or not you knew exactly who was the director or the owner, ultimate owner of VR Laser at the time, and whether they may or may not have been connected particularly to somebody in high position in the country. What I'm just interested in is what Mr. Saluji told you. And I'm particularly raising this question because the chair, obviously, he will determine in due course what is ultimately relevant and how to deal with it in his report. But it does seem that an issue that is worthy of consideration is what the role is of officials at senior level within state entities. Now, I appreciate that Mr. Saluji was far more senior to you in the hierarchy of the Denel Group, not so?
Correct, Chair.
And obviously he has to answer, and he has answered to an extent, and he will still answer when he's called again. But I'm just interested in how you dealt with it. And you're not on trial here, but the Commission's entitled to hear your evidence as to how these things happened and why they happened. Now, you've acknowledged very fairly earlier that there are some things with hindsight that you realize shouldn't have been done. You've also said that you were naive in certain respects. Do you accept, though, that it wouldn't have just been a good thing to have at least said to Mr. Saluji, I'm sorry, but I'm not prepared to accept an instruction like that. Instead, you just said, don't worry, they're going to get business, which seemed to give him assurance. It seemed to show him you're going to comply with the request to favor in a procurement setting VR Laser for a specific contract because they were politically connected, not because they were the best supplier. Now, did you not have a duty as a responsible state entity official to be taking a stance like that?
In hindsight, I should have. Chair.
Yes. Okay. What I'd like now to deal with is the process that was followed for this particular contract. And here again, we're dealing with a single supplier contract. Just to make sure that I've covered it properly, Mr. Saluji hadn't given you a similar request before the Hoefyster contract was awarded. That was, in fact, as I understand your evidence, something that did come from the division DLS itself. Correct. The idea to award the Hoofeester platform hulls contract to VR Laser.
Correct, Chair.
That came from your own internal process.
Correct, Chair.
It was ultimately approved by the GCEO, but he didn't start the whole thing.
Other than saying before the time that VR Laser is an important supplier,
Yeah.
The initiation came in totality from the division.
So he, prior to his raising his requirement that you initiate or that you process a contract awarding the single supplier status from DLS to VR Laser, he'd had another earlier discussion with you specifically about VR Laser. Is that right?
In February, roundabout, in February 2014,
Right.
he had a discussion with me in which he said VR Laser is a very important supplier, and in that discussion I told him we are busy with the processes. They are a very good supplier in a niche market. They in all probability will get work, don't worry.
And so that was at the stage that the platform hulls contract was being prepared?
That was before the platform.
Before
it was busy being prepared at divisional level, yes.
Right. Did he raise this in 2014 with specific reference to the platform hulls contract or in general?
No, Chair, that was not product specific. It was a general comment.
But in 2015, he made the same request, but specific to the contract that he wanted you to award to VR Laser. Is that right?
Correct, Chair. His instruction was an attempt to verbalize his instruction was put on the minutes of the EXCO meeting, and it basically said it must be MOU with certain single that
Right.
aims to achieve single source status,
Right.
and that protects obviously Denel's interest.
Yes. Chair, it's getting late in the day, and you have understandable limitations on the time that you've already indicated to us. May we be permitted to use the remaining time to start the questioning relating to the process followed in the award and the difficulties relating to procurement compliance?
Yeah, no, that's fine. We still have about 10, 15 minutes.
Thank you, Chair.
Yeah.
Right. Mr. Burger, in relation to this contract, you have indicated earlier that you came to realize that, with the benefit of hindsight, that there were some difficulties in relation to the award of this contract. Did I understand
Which
you?
contract is that?
That's the single supplier contract.
Yes, Chair.
And what do you say was a defect in the award of that agreement?
Firstly, at the time, I did not see this as a contract. I saw this as a strategic document, agreement. I also did not see this as a document that stops any normal procedures to go through the process of giving a tender and getting the normal approvals. In other words, it does not give me, as a divisional CEO, the carte blanche to just place orders. It still had to go through all the relevant parties, as indicated in the Delegations of Authority. So in my mind also, in the past, much lower levels than me used to conclude these strategic agreements. So I did not, without studying the policy, I did not think that it is a problem at the time. When it was approved and we went through the negotiation with VR Laser and certain changes were made, I therefore had no hesitancy to sign the document because I felt it was a fair, balanced document and it represented the instructions that I got from the CEO. So I did not, I didn't feel that we did anything wrong at the time.
So that explains why you didn't think there was anything wrong at the time. Now, can you please answer the question that I put to you, which is, with the benefit of hindsight, you've acknowledged earlier today that there was actually something wrong.
Yes.
You didn't realize that at the time, you say, but what is it that you acknowledge now?
I did not realize it. If you allow me, it's one sentence. When it then I came to learn that we should have gone out on open tender, and I realized I only got to know about this problem almost a year after it was signed. I know it was discussed internally at Denel Land Systems. I wasn't aware of it. I was told about it literally in the passing, and then there was a EXCO meeting where it was discussed, and I raised the opinion that yes, it's not possible to go out on open tender, because the only way to do something like this is to send drawings of complex fabricated components to potential partners, let them tender on it, and give their explanation with regards to their capability, their processes, all that. And just before that, we went through that with the hulls. So we did that.
So you did that with the hulls, but not with the single supplier?
Yes, correct.
Can I just stop you there for a moment, if I may? Didn't that actually alert you when you did get the instruction from Mr. Saluji to award it immediately and directly to VR Laser without even going out for 3 bids? Didn't you think, hold on, last year we awarded a contract, albeit to VR Laser, we did it after at least some sort of process of competition, competitiveness. We at least got 3 bidders. Why aren't we doing that here? Did you raise that with Mr. Saluji? Did you raise that in your own mind?
I did not. So sorry, maybe I didn't come across clearly. The argument that we should have gone out on open tender, and my argument was it cannot be open tender, it needs to be closed tender. That argument was raised to me, came known to me by early 2016. Yeah. So after the agreement was signed. So at signature of the agreement, I thought it was well within the group CEO's mandate to sign strategic agreements of that nature.
Yes.
As the process unfolded, and in the last couple of weeks, I came to realize, but how things actually work nowadays is you have to go out on open tender for this. So at the time I really did not realize it, and this is why I said, well, it's a MOU, or MOA, let's go for it.
Would you explain this? Would you attribute this, the fact that you didn't know at the time, and you've come to realize recently, again, to naivety on your part?
Chair, I don't know what the correct word is.
Well, if it's not naivety, what would it be?
I wanted to see this happen. I thought it was a good idea for the business. Maybe I did turn a little bit of a blind eye. Maybe I thought, why this operational focus? But it suited me, and I supported it. And naivety, and not knowing what the correct procedures should have been on Treasury level.
Yes, and we've already debated whether you should have known those procedures, and I think you have acknowledged that you should have. But I want to just, if I may, Chair, just in the final few minutes of the time left, just explore this last aspect of the naivety and the lack of knowledge of the processes. You knew that there were some processes that were applicable, or that were required, not so.
At the time, I knew of the supplier contract processes that I did.
Yes. And in fact, as I showed you earlier, when we took the lunch adjournment and we confirmed this on record, on the record straight after lunch, there were two versions of the supply chain management policy. The one was 2013, before the award of the Hoefyster platform hulls contract, but the other came into force after that, and
Correct.
wasn't that applicable at the time of the award of the single supplier contract in 2015.
Correct, Chair, it was.
Did you have in your possession, had you been sent, or did you have access to the then current SCM policy?
I had access. I didn't have one on my table, but I could find access.
Presumably, when the board at head office level decided to approve the adoption of the new policy, they would have informed you as CEO of a division.
It was distributed, Chair.
Yes. Now, apart from your knowledge that there was now a new policy, you also had Ms. Malashlela in your division, who headed the supply chain management there, and you also had Mr. Mlambo, as we know, at head office, who was the head of supply chain management for the whole group.
Correct, Chair.
Now, what I want to ask you is this: even if one assumes in your favor that you weren't familiar, even though you had access to it, you were aware that there's a new policy, you weren't aware, though, about the detail that required, for example, a competitive process, and you weren't aware of the Constitution and the PFMA requirements to that effect and so forth. With the benefit of hindsight, are you prepared to acknowledge here that, in fact, any ignorance of that must have been dispelled when Ms. Malashlela and Mr. Mlambo raised serious concerns about the award of this contract, the single supplier contract to VR Laser, and specifically raised these concerns that there had been non-compliance and the contract couldn't go ahead? What I'm suggesting to you, if you were genuinely ignorant before then, that ignorance was dispelled by them drawing this to your attention. Despite that, you went ahead and recommended the contract in your motivation, and then ultimately signed it on behalf of DLS.
I state again, Chair, although there was, I learned now, discussions within Denel Land Systems, I only got to know about the unhappiness and consequences in 2016. Number one. Number two, in my mind, I also said this is a strategic document.
Sorry, this is a strictly?
It's a strategic
Document.
I didn't, wrongly, but I did not put it in the same category as a supplier contract.
But they were entitled to supply as a single supplier to the exclusion of others.
Understood.
And unless they were in breach, you had to go to them first.
Correct.
Not so.
Correct.
So it was a supply. So can you just explain, this is a final question if I may, Chair. Can you just explain why you did not see this as a supplier agreement? It was a single supplier, Nocha. To call it a strategic document surely doesn't detract from the fact that at the end of the day, that contract required, maybe not the memorandum of understanding, because that's sort of a wish and we might do this and we hope to do it.
Correct.
But the memorandum of agreement that was signed by you, not so?
Correct.
Did actually give them enforceable rights to supply you Denel land system. Before you can go anywhere else, unless they're in breach, they must be given that business.
Correct, Chair.
Not so.
Correct.
So how does the label of this being a strategic agreement and therefore not a supply contract, how does that tally?
The reason, and I state again, and my apology for repeating, in the past, these sort of agreements, in the distant past, these sort of agreements were regular. And that didn't mean that if somebody held a single source agreement, that there should not be normal processes to give that order to that person. And you're right, it's a single source agreement. But
I'm sorry, before I let you carry on, can I just debate that last point with you? Surely every contract has to follow certain processes. And you're suggesting it still required those processes. But those processes include a competitive process for competitive bids.
Correct.
And the very point of this agreement, that's why Mr. Saluji was wanting you to give it to these politically connected people at VR Laser, was to ensure that you didn't have to go through an open tender, or for that matter for an RFQ as you had done with 3 bids in the Hoefyster. It was precisely to avoid those processes, not so.
True, Chair.
Thank you, Chair. Perhaps we obviously can't finish the witness. We have a fair
Yes.
number of questions still.
Yeah.
We've made good progress, I believe, but I'm afraid we have to
Arrange.
take up your indication that
Yes.
we need to have another opportunity.
Yeah.
I've indicated, taken the liberty of indicating to my learned friend, Mr. Krauser, that the scheduling will be done as far as possible in consultation with him, but obviously up to a limit. We can't, for example, as colleagues say, well, I'm tied up for the next 6 months or whatever.
Well, let me make sure there is no misunderstanding about that.
Yeah.
If the date that we are looking at is close, there would be consultation with all concerned. But if the date gives you a reasonable time, we won't negotiate the date. We'll just, as long as it gives you a reasonable notice, then we'll just fix the date. But if we are looking at close and we won't be giving you reasonable time, then we will seek to see if we can agree with you on the date. Okay, you understand?
Mr. Chairman, we do. We will obviously
Do your best.
try to accommodate the Commission as
Yes.
best we can.
Yes.
But for instance, and that is why I welcome the suggestion of Mr. Kennedy. For the next week, for instance, I'm not available.
Yes.
But after that,
Yeah.
Mr. Kennedy has also indicated to me that the Commission would probably accommodate Mr. Berger's evidence after 5 o'clock in the
Yes,
afternoon.
we have evening sessions. Yeah.
And then we're readily available
Yes, yes.
at any time.
Yes.
I just have a problem for the next week.
No, if we're looking at next week, we would seek to agree with you on the date, because that's close.
Yes.
Yeah, so we are not looking at next week, because you are not available. And in all probability, we will look at an evening session.
Yes.
And then it enables you, in case you were in court during the day, to still be available.
Thank you,
So in
Chair.
all probability, but if it's not an evening session, that is still a possibility. But if we are able to give you a reasonable notice, we'll simply determine the date. If it's close, we'll talk.
We would be grateful for that. Thank you,
Okay,
Chair.
no, that's fine.
Thank you, Chair. Then we would ask for the proceedings to be adjourned at this stage, with the continuation of the questioning of Mr. Berger to be postponed to a date to be determined by you, Chair.
Yes, no, that's fine.
On the basis as indicated, but we do have another witness that we propose to call tomorrow morning.
Yes.
Mr. Mancha, the former chairperson of
Yes.
the Denel board.
What's your estimate of how much time you still need with, for questioning Mr.
For Mr. Berger,
Uh-huh.
I would think probably no more than 2 hours, Chair.
Oh, okay, because that
Perhaps
can easily
less.
fit into an evening session.
I'm sorry, Chair?
2 hours can easily fit into an evening
Thank you,
session.
Chair.
Yeah, yeah.
Gives new meaning to the term night court, Chair.
Sorry?
It gives new meaning to the term night court.
Yeah, no, we have to try the best we can to finish the work of the commission.
Indeed.
Okay, so, Mr. Becker, you do understand and you have no problem.
I understand, Chair.
So we are going to adjourn for the day, and tomorrow I'll hear the evidence of another witness, but arrangements will be made for Mr. Becker to come back in order to complete his evidence. We adjourn.
All rise.